can you please look up this thing?
See if we can figure out something.
Breathing deeply, hoping the portal worked. Going in to turn off the heart in the meantime. I don't know if it worked. It looks like it worked. It looks like it worked. I need to put this on. Okay. It looks like it worked. Amazing. Okay, so, oh, sorry. Looks like Judge Washington currently has an interpreter. Yes, she does. Let's not do that one. Let's go to should we go back to Webster, see if there's anything interesting going on here? It didn't help. I'm lost. Did the portal not work? That is frustrating.
Do you pay any child support out directly?
I do not, ma'am. No, because
Proof of life.
Just going back a little.
Mr. Patterson's obligations are concluded.
Oops.
Looks like they concluded August 15th of 2022.
Thank you, Your Honor.
You're welcome.
That's all you need from me?
That's all we need from you. You may go, sir.
Okay, thank you.
You're welcome. So Thomas Cruz, is that your name, sir?
yes, ma'am, it is.
Let's take up your case. We are on the record in 2024, TR 1506, State of Kansas versus Thomas Levi Cruz, Jared Regier for the state, the defendant appearing in person and pro se. Sir, you're here on one count of operating a motor vehicle without proof of liability insurance. This is a B, non-person misdemeanor. If you did have insurance, get that to the county attorney and they'll probably dismiss the case. If you did not have it, you're looking at a B, non-person misdemeanor. The minimum fine is $300 up to $1,000, and the possible jail sentence is up to 6 months. Do you want to look into the diversion we've talked about or proceed in another manner?
I would like to first reach out to an attorney.
All right. Do you want to apply for, do you want to hire an attorney or do you need to apply for court appointed?
I may need to apply for court appointed. I'm not real sure that I will qualify for that. So I would like to apply for that, but I am going to reach out to one on my own as well, just in case I don't.
All right. Are you employed?
I am, ma'am.
What do you make per month?
Gross or net?
Well, what's your gross? What's your net?
My gross is give or take about 4,000, and my net is like 2,800. I make about $1,400 every 2 weeks, but I'm also a single dad with 3 kids, so I don't know how that.
All right. So your family of 4, are you supporting the 3 children?
50% of the time, yes, ma'am. I have 50-50 custody with their mother.
And what is your your mortgage?
My rent is $1,300 a month.
And your utilities?
Altogether, roughly, I'd say $375 on average. you average the summer and winter months. They ran a little higher in this summer, and then they drop down in the winter.
Let's see. Do you pay any child support out directly?
I do not, ma'am. No, because we split them 100%, 50-50, 26 weeks and 26 weeks.
Okay, do you have any other expenses, car payments, anything like that?
No, ma'am, I do not.
Don't have any other expenses?
Just groceries.
Groceries, food, clothing, personal items?
Yeah, just stuff like that.
For a family of 4, well, under the old guidelines, no. Under the new guidelines, for a family of 4, you do qualify.
Okay.
So I will appoint Darren Patterson,
Darren Patterson.
Darren Patterson, Patterson, 316-322-7700. Your next court date is November 4th. Be back here by Zoom November 4th at 8 a.m. Call Mr. Patterson's office immediately after this hearing. Give him your name and contact information. You do not need to make a bond because this is an unclassified misdemeanor.
Your
Are
Honor,
you showing something different, Mr. Regier?
with all due respect, Your Honor, count 1 of the information does appear.
Oh,
No proof of insurance, a class B non-person misdemeanor under KSA 43104.
thank you. You're absolutely correct. Deputy Court Security, you were correct. So, Mr. Cruz, you will need to go into a breakout room with Court Security too. Your bond will be 1,000 OR.
Okay.
Sorry to interrupt. I was just going through the videos I've saved, and I've been meaning to ask if I should be watching that pink cocaine influencer thing. Is that something you guys would be keen on watching? I need to check time zones to make sure that it won't be like middle of the night. But I just saw it pop up and thought it could be a cool thing.
Missy, can you put them in a breakout room? If you could, Missy, that would be Thomas Cruz and Court Security 2. There's nothing further. We'll be in recess on Cruz. Take up Miss Henry. We are on the record in 2024 TR 1521, State of Kansas versus Renee Henry, Jared Regier for the state. Miss Henry, you appear as the gentleman before you on 1 count of operating without insurance. As I told him, this is a B misdemeanor with a fine from $300 to $1,000 and a possible sentence up to 6 months. Do you want to look into diversion or proceed in another manner?
I would like to look into diversion.
I will enter a not guilty plea for you then, so you can do that. And we will set your case. Let's see, is that November 6th, Destiny?
That's correct, Judge.
All right, be back here November 6th at 9 a.m. unless you are diverted by then. Did you get the website for diversion?
Yes, ma'am.
All right, so your court date is November 6th at 9. You're applying for diversion. Your bond is 1,000 OR, and when that gentleman from Court Security 2 comes back, you'll need a breakout room with him, and he is here. So, Missy, would you please put Callie Henry and Court Security 2 in a breakout room? We'll now take up Hoover, Katie Hoover, if you'll start your audio and video. We are on the record in 2024 TR 1473, State of Kansas versus Katie Ray Hoover. Jared Regier for the state. Ms. Hoover appears in person and pro se. Ms. Hoover, you're here on one count of operating a motor vehicle with an expired tag. You've probably heard me tell folks that's an unclassified misdemeanor with a fine up to $2,500, a possible sentence of 30 days to 6 months. Did you want to look into diversion?
I do, Your Honor. I'm also interested in talking to an attorney, but I don't think that I will be able to afford one. I just don't. I'd like to know both my options there.
All right. Are you employed?
I am employed.
And where do you work?
I work for Strawbridge Studios.
Strawberry Studios?
Strawbridge.
Strawbridge Studios, okay. And what do you make per month?
It varies. For the summer, I've been part-time, so I'm making probably $800 or $900 a month.
And are you married or single?
Single.
Do you support any children?
I do not.
All right. I would say that you probably do. You don't have any other income?
No.
All right, then I would say you qualify, and I will appoint Darren Patterson.
Thank you.
Get his name and number by chance?
I did write down his name, but I did not catch the number.
All right, it is 316-322-7700.
316-322-7700.
That's right. Your next court date will be November 4th at 8 a.m.
Okay.
That's me, November 4th, is that right?
That's correct, Judge.
Be back here by Zoom, November 4th at 8 a.m. with Attorney Patterson. You need to call him as soon as this hearing is over. You have your court date, your attorney, and you do not need a bond. Mr. Regier, anything further?
Your Honor, it would appear that the court has appointed Mr. Patterson to this case. It would also appear that at least the perspective of diversion was pretty respectfully suggested that any communications to my office should be through the court-appointed attorney.
Yes, don't go out and apply for diversion without talking to Mr. Patterson.
Understood. Thank you.
All right, you may go, Ms. Hull.
Thank you.
You're welcome. Caitlin Humphrey will be on the record in 2024 TR 662, State of Kansas versus Caitlin Humphrey. Jared Regier for the state. Is Caitlin Humphrey present? Caitlin S. Humphrey fails to appear. Council recommendations. So she was served with summons March 13th of 24. I show she was.
Find the sponsor, which that was the toughest part, is finding someone that meshed with you, or even, you can just feel comfortable speaking with.
We're no longer in translator, so let's see.
Maximum penalty. Well, actually, this is a technical violation. You could be sentenced to do up to 5 days in the Washington County Jail. Do you understand that, sir?
Yes, ma'am.
All right, thank you. And then we'll wait a while to handle the white.
Race, right?
Thank you. All right, we're here for a violation of probation today. Mr. Wright, I'm going to arraign you on the violation. The violation alleges that you tested positive for alcohol on July 31st, 2024 by ETG in violation of your probation conditions. You have a right to have a hearing on this matter, at which time, if it is found that you violate the terms of your probation, you could have your probation revoked and you could be sentenced to the maximum penalty. Well, actually, this is a technical violation. You could be sentenced to do up to 5 days in the Washington County Jail. Do you understand that, sir?
Yes, ma'am.
All right, thank you. Ms. White, have you had a chance to go over the violation with him or someone in your office?
I believe Mr. Works did talk to him about that violation. Is that correct, Mr. White? And you
Yes.
wish to admit to you wish to admit to testing positive?
I did test positive, yes.
Okay.
Sir, please raise your right hand to be sworn. You swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You understand you have a right, you can lower your hand, sir. You understand you have a right to have a hearing in this matter, at which time if it is fine, I'm sorry, I told you all that. You're gonna waive your right to have a hearing and you're gonna admit to the violation?
Yes, ma'am.
All right. Is it true that you tested positive for alcohol on, July the 31st?
Unfortunately, yes.
It is unfortunate. Defendant appeared and has admitted to the violation. Are you satisfied, Mr. Barnett?
Yes, Your Honor, thank you.
Satisfied, Your Honor.
Thank you. All right, is there anything you want to say to your, regarding your client before we impose sentence?
Just that I don't think we'll be here again on this violation. Is that correct, Mr. Wright? There will be no more slip
That is
ups?
very correct. I just found a sponsor and everything. I did what you said, do the sponsor, get the sponsor. I'm so happy. I've been good for the last few weeks now, just in being able to have that person to talk to and clarify things and put it in justifications that are understandable. That's actually a really big ups. And I took the BTC class, and I tell you, without bad language, I should have had my behind there. That should have been the first one before math class, for sure. It was very enlightening, more than enlightening. I don't know a word for it, but much better than I ever understood, for sure. I like Mr. Rhett. He was good, very, very informative.
So you were with Mr. Rat Race?
Yeah, I called him a couple different times, even after the class, just to talk to him about like finding a sponsor, which that was the toughest part, is finding someone that meshed with you, or even, you can just feel comfortable speaking with. And you just put it in the layman's terms, like, like it's not easy, but it gets easier. And I can tell you, just like letting go and letting it in, it's been helpful. I'm trying to do my 90-90 right now. And I had my therapist email Ms. Schraubs and my community service lady. I'm still waiting to hear back from her. And I have to meet with my sponsor so he can make it official that he's my official sponsor. And then he'll email Ms. Schraubs as well. Yeah.
Anything from you, Mr. Barnett?
It sounds like he's has some awareness of what needs to be done, so that's a positive.
I agree. So a lot of times when this happens, people just give me a lot of BS, to be honest. It appears to me that you are taking this very seriously, that to the 90 and 90 and how the class is really affecting you. And I can hear the sincerity. So the sponsor will help you with the part that's really hard. That even though you're doing all this, the cravings get so difficult that you don't know what to do. That person can help you with what to do and how to get past that until those cravings pass. And you no longer have those urges. It is a process, Mr. Wright.
I'm seeing it. I am. Cravings are, it's weird because I never really felt like it was a problem until it was like pointed like to you, like, hey, you should check this. So yeah, serious.
All right. I'm going to follow the recommendation. You do need to complete an assessment with Don Firm and enter any treatment immediately if it is recommended. And we're going to do a review in 45 days to make sure that you're doing what you're supposed to be doing. Okay. Given the state that we are in this case, I'm going to have that before me. So that's going to be on October 9th, 2024 at 10:00 a.m. Make sure you're still doing your program, sir. Okay?
Oh, I will be. I'll be a lot better, I promise.
All right. Thank you. Take care of yourself.
You too. Thank you, Judge.
You're welcome. Bye. Bye. Okay. And then you're gonna put, you can go ahead and put Miss, yes. So we're gonna put you in the breakout room, Miss White, with Mr. Roberts at this time.
Okay, thank you.
The court will recall the matter of Ypsilanti Township versus Wesley Smith, case number 24T00127.
Paul Barnett, excuse me, Paul Barnett on behalf of the township.
Assistant Public Defender Allison Muller here on behalf of Wesley Smith. Mr. Smith, can you state your name again, please?
Wesley Smith.
Thank you. All right. You had a chance to talk to your client regarding the employment?
I did, Your Honor, and I'd just like to address it. And I guess the conclusion is I'd like to ask permission from the court for Mr. Smith to continue his employment. I do understand that it seems a bit contradictory, him working at a bar and being on probation and strictly ordered not to drink. He was just promoted recently to a management position. He was promoted August 12th. So that was a big jump for him. And this isn't, this is, I feel like, of just slight importance, but it is an older case, November 10th, 2022. He has, of course, refrained completely from drinking since his arraignment on June 5th. So he has, at least has that now coming up almost on 3 months, kind of showing that he can maintain that position without drinking. He will be on his probation, regular testing 4 times a month. So he'll have that oversight, as well as Mr. Smith told me he's been very open and honest with his boss at work. And his boss pretty much told him point blank that if he ever sees him drinking, given that this case is going on and given his position, he would lose his position. So I think he'll have a lot of oversight. Mr. Smith, both times I've talked to him, seems to be taking this very seriously. He was straightforward with me from the beginning. He admitted he was wrong. He wanted to resolve the case. He knew that he'd be on probation and just really took responsibility. And I do think, at least given what he's told me, I think he'll be able to maintain this position and refrain from using alcohol.
Thank you. I will say this court is obviously very concerned about the nature of this offense. There's a 2-vehicle crash. All of that is concerning. But in addition to those concerns is the concern that comes out of the assessment itself about his own needs and the need the assessor finds that he does have alcohol dependence, and being around alcohol in that environment is very concerning for me, and it should be for him, because if he violates, he's going to jail. So, Mr. Barnett, do you have any thoughts on the whole employment? Well, let me ask you this before I get to Mr. Barnett. He's been promoted to a manager position. Is that correct?
That's correct, Your Honor.
What does that look like? What does a manager position in the bar look like? So I have some context within which to make my decision.
And Mr. Smith can probably speak more to that. I did ask him if they're somehow separated from the bar, maybe a separate office or something. It's not separated, so he is right there directly working. As far as his day-to-day kind of what his work looks like, Mr. Smith, maybe you can shed some more light on kind of what that looks like.
I would handle ordering of food and alcohol, as well as doing scheduling and payroll. I do deal with clients that are more upset, trying to resolve those kinds of problems as well. I work on our computer system, making sure that our point of sale is correct and at a market price that's fair.
You're not bartending or anything like that at this point?
I do bartend.
All right, Mr. Barnett, what was your position on this?
Well, I share your concern, to put himself in a position, especially if he's bartending and handling the alcoholic beverages. And it does appear from the recommendation that bars sort of played a big role. I mean, he said he was coming from a bar at the time of this incident. In his assessment, he talked about drinking primarily at bars. It just seems like that's a pattern connected to his alcohol use. So I think it is concerning if he's employed in that area. I mean, I don't want to have someone not have a job either. But I guess I'll leave it in your discretion, but I do have those concerns.
Thank you. Anything else you want to say, Mr. Smith, before I sentence you?
No.
Well, I think everyone here should be very clear on what our concerns are. They are very valid concerns. Mr. Smith, I would I'm not gonna say you can't work in that capacity. I will say that you should talk to your boss about making sure that you don't have to do the bartending part, at least. I think that is much more of a, I guess, a test of your willpower than the other part when you're actually physically handling the alcohol. I'm not gonna, at this point, say you can't do it. But if there are any instances of testing positive, not only are you looking at losing your job because I'm going to order you not do it, but I'm also going to put you in jail, which is going to maybe end up having you lose your job. So that it's very serious for you at this point. One of my real concerns is that after this incident occurred, you continue to drink. You know, that's concerning for me. I do appreciate that you were honest about it, though. So that's the reason why I'm giving you another opportunity, because of your honesty about it. So it is the sentence of this court that you serve 93 days in the Washtenaw County Jail, credit for 1 day served, 92 are suspended, 6 days for a total of 48 hours of community service, 18 months on probation, fines and court costs in this case for a total of $795, $30 per month probation oversight fee, complete an assessment at community corrections and follow all recommendations, and sign a release of information with the probation through the provider. Schedule this assessment within 1 week of sentencing. If community corrections does not recommend any program, then you will complete the armed DUI class. Attend the MAD victim impact panel within 45 days of sentencing. Provide a certificate of completion to the probation agent. Report to the probation officer during the second week of each month via the online reporting platform. They're going to send you a link to that in an email. Make sure you use that link to report every month on the second week of each month. Meet with probation when and where directed, including any and all home visits. No use or possession of alcohol, marijuana, illegal drugs, or drug paraphernalia, and no being in the presence of any of those. The defendant may continue to work at his place of employment unless there's a violation. No use or possession of a firearm, firearm components, ammunition, or other dangerous weapons. You must drug and alcohol test 4 times per month and any other times as ordered by the court, probation, or any police agency. You're to attend 12-step meetings 2 times per week and provide proof of that to the probation agent on a monthly basis. Review, in this case, with probation agent Straub via Zoom on October 25th at 9:30 a.m. Do you have any questions about your sentence, sir?
No, I do not.
All right, so what's going to happen is you're going to call the probation department tomorrow after 9:00 a.m. and they'll go over this agreement with you and have you sign a contract for your probation. And then you'll meet with Ms. Straub. If I have to see you again, that means that's not good for you. Okay?
Okay.
All right. I wish you the best in this, and given how well you've been doing since June, I hope you can continue that and that you do well on this probation. Okay?
Thank you, Your Honor.
You're welcome. Take care of yourself, sir. Did you put this here? Okay. All right, the court will call the matter of Kyle Blankenship, case number 22T00936.
Paul Barnett on behalf of the township.
Kerma Dadush on behalf of Mr. Blankenship, seeking permission to practice under MCR 8.120.
Thank you. Mr. Blankenship, please state your name, sir.
Kyle
Permission is
Blankenship.
granted.
Thank you.
Thank you, Mr. Blankenship. Mr. Blankenship, you're here today because you were supposed to pay your restitution, and I think we left the pay your fines and costs, and we left the restitution open for 30 days, which protects around here. Mr. Barnett, any restitution?
Your Honor, I don't have any information as to restitution, so we're not making a request at this time.
All right. How is it going with your fines and costs, sir?
I just haven't paid because I wasn't sure if there was going to be restitution or not. So I can pay it today. I can pay it by Friday. It's $275, correct?
$375.
Okay. I can still pay that today or Friday.
I'll put it over to September 25th. If it's paid, then you don't have to be here.
Okay. Thank you.
Your Honor, could you repeat the date?
September 25th at 10 a.m.
Okay, thank you, Your Honor.
Thank you, Mr.
Thank you.
Blankenship.
Thank you, Mr.
Ypsilanti Township versus Maxine Valverde, case number 24T00136.
Paul Barnett on behalf of the township.
Assistant Public Defender Allison Miller here on behalf of Maxine Valverde. Ms. Valverde, can you please state your name?
Maxine Valverde.
The court will call the case of Maxime Acuna Valverde is what we have in here. 24T00136. But it's not right in the docket. It is Valverde. Is her name actually hyphenated, or has that been changed?
No, it's hyphenated on yes, with the Acuna. But my first name is Valverde. I don't ever use the Acuna ever.
All right. When you come into court, please use the Acuna because that's how it's set up. Otherwise, you'll be put at the end of the docket because we take a while to figure out who you are. Okay.
Okay.
Thank you. All right. We're here for a pretrial today.
Yes, Your Honor, I understand the offer in this matter would be to operating while visually impaired. Ms. Valverde does want to move forward with that. Unfortunately, I did catch belatedly. I learned this week. Ms. Valverde is not a citizen, so I've already put in the immigration request that's been approved. That should happen in a matter of a week or two. In the meantime, I've given her, Ms. Valverde, I think with probation's permission, we'll be doing an assessment with Don Farms in the meantime, so that will be accomplished and we should be able to proceed at the next pretrial. So I'm requesting an adjournment.
No objection.
All right. The pretrial in this matter will be adjourned to September 25th, 2024 at 9 a.m. 9 a.m. on September 25th, ma'am. Bond is continued. And
Sorry, we did a quick jump there. How's the audio?
Good morning. I'll be with, or good afternoon. I will be with you in just a moment. And Attorney Chenault, really quickly.
Yes.
With the last case, did you say that he was just released?
Yes, he said he was released on Friday, this past Friday on the 16th.
Okay. Thank you.
You're welcome.
Yes.
I don't think it's me. But if it is, just let me know and I'll do the change again.
Now calling case number 22T00708. This is Ypsilanti Township versus Shaina Lawson. Appearances for the record, please.
Assistant Public Defender Sonia Chanel on behalf of Ms. Lawson. Ma'am, state your full name for the record.
Shaina Lawson.
Thank you.
So today is the date and time set for an arraignment in this matter. What I am seeing is that you were sentenced by the judge. It looks like you had a hearing date set for today at 11 a.m. in person in front of Judge Washington. However, a violation of probation report indicates that you had a positive ETG test on July 1st and then missed 3 tests after that. Attorney Chanel.
Thank you, Your Honor. We stand muted to the charges and regarding bond. I would like the court to know my client is 36 years old. She works part-time doing secretary work. Your Honor, she explained that she did not have the money to continue paying for the alcohol testing. She also expressed that she did relapse a few times by drinking alcohol, but would like to return to rehab for alcohol treatment. Your Honor, there are no other active cases, but only a few holds, so we are asking for a personal bond. Thank you.
Okay, thank you. Okay, at this time, the court will set this matter for August 28th. So that will be a violation of probation hearing, August 28th, 2024. That will be at 10 a.m. over Zoom before Judge Washington. And at this time, per the judge's order, bond is denied. Attorney Chanel, do you have anything else?
No, nothing further. Thank you.
Go until the jail that you are finished, your hearing is concluded.
I couldn't hear you.
Said you are free to go to the door until the jail that you are finished, your hearing is concluded.
By the way, this seems to only be 15 minutes long, so we might be jumping again. But the vote was for mixed bag, so we are mixing the bag big time today.
Our kitchen supervisor.
Your Honor, are we all set?
I thought we had another one. Hey, do we have Jonathan?
So I
The-
don't know. Yeah.
Okay. Let's go here. I mentioned earlier about Judge Allen. This is Judge Allen. I really like him. I've been watching quite a lot of his videos.
Case 24-11-17. People of the state of Michigan versus Maurice Todd. Answer the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Seated with you is
Brad Mack was on behalf of probation.
Mr. Nickel.
Assistant Public Defender Scott Nickel on behalf of Mr. Maurice Anthony. I have had a chance to review the allegations of bond violations with Mr. Anthony.
Mr. Nickel, what do you propose to do?
He wishes to have a contested hearing.
That's certainly within his rights to do that. So what I will do is I'll simply arraign him with regard to the allegations and set a bond. Mr. Anthony, you have been placed on bond conditions by, looks like Magistrate Hoover, that this occurred on August 9th. And it looks like you were placed on special report bond conditions, which included no weapons and 2 random attacks. And then there are allegations, look like there are 8 of them. First allegation is that you failed to submit to a PBT between the hours of 9 and 11 p.m. on August 14th. The second is that you failed to submit to a PBT between the hours of 6 and 8 a.m. on August 18th. Looks like you submitted a test at 8:19 a.m. Third, that you failed to submit to a PBT between the hours of 6 and 8 a.m. on August 19th, and that the test was submitted at 8:23 a.m. Fourth, that you failed to submit to a PBT between the hours of 6 and 8 a.m. on August 20th. That the test was submitted at 8:08 and had the motion before 8 o'clock. Fifth, that the defendant failed to report truthfully to the probation officer on August 9th. The defendant provided false information regarding his current drug testing location and prior use of substances. That he failed to enroll in testing and on-site substance use testing on August 10th. That he did not enroll until August 13th. Seventh, that the defendant failed to report truthfully to Mr. Mock on August 12th. The defendant reported that he was unable to submit to testing at on-site due to them not being open on the weekends. This information was not true. But apparently that they are open on the weekends. And number 8, the defendant failed to submit to testing at on-site testing on August 16th, 2024. So you do have a right to have a hearing and to contest those allegations, but now you're aware of what the allegations are. So you can have your contested hearing, but I'm going to set a bond for you. Your bond is going to be $20,000 cash surety. If you're able to make bond, all of the bond conditions are continued. And if you're not able to make bond, we will see you when you see.
Excuse me, sir. I just had surgery, and it was Friday. I got out. So Friday was the 9th.
Can I stop you? You just stop you for a second. You just asked for a contested hearing. We don't want to talk about what the allegations might be. Because you asked for a contested hearing, so they have to prove what's going on, and I don't want you to say something that could compromise your ability to have that hearing.
So I was speaking because like I'm 100% with myself on this part. Like I'm not even 99. I'm 100% because I've been following everything on the rules, like with the drug testing and.
Don't talk when I talk.
Okay.
You ever notice I don't speak when other people speak? So it's really, really important to understand that you have to be on point for 100% to use your language all the time.
No, you said my language?
Using your language
Oh,
of 100%.
okay.
Yeah, I use your language because it's something that I understand as well.
Yes.
But you have to be 100% all the time. It's not matter. It's not before me because you were 100%. It's before me because there are some problems with what it is that you did in terms of your compliance according to this law. So we're going to require that he show, that he prove that you did not comply with all the terms and conditions. That means that you had, there's a place where they said that you didn't show up for a test at all. Then other instances where you showed up for testing late. And showing up for a late test is still a violation. And when you miss a test, it's like you use violation because you don't have to prove that you were not using. So when you don't show up, or if you don't show up on time, or if you show up, so the other allegations that you didn't enroll in testing at all. So all of those are problems. Yeah. We should probably talk to you a little bit first.
Well, I mean,
you should talk to you a little bit before you say something.
Okay.
Okay.
Your Honor, just one thing Mr. Anthony wants to make clear is that he did have surgery recently. He's got to have another procedure on it in a couple of days. So he's asking the court would reconsider the bond that it set or schedule the hearing as soon as possible.
We're going to set hearing for as soon as possible. It looks like it's going to be on Thursday. It's 22nd at 9:30. Anything else for the record?
Nothing further.
He's going to be custody until you can postpone.
Can I say one more thing before I basically go to jail? I honestly want to say, like, on that paper, it's basically saying I was late. So I can actually man up and say that I thought that it was one time I woke up about 5 minutes late, to blow in the thing. And I was a couple minutes late, and I can just say that I was late, It was basically more of like, oh, I was late, and I can basically man up and say I was late on blowing, And man, I'm begging if you can just give me another chance just on my bond, and I won't be a 1 minute late at all. Like I just admit and say that I was wrong, because I was wrong for being late, but for dropping and everything and doing everything I was supposed to do, like I wasn't doing any drugs. I was coming in here today to actually ask, could I get this off of my bond, because I don't even do drugs at all either. or drink. I don't do none of that stuff at all, man. I was just asking, could you just, this could be more of a warning just to not be late again. But, you don't have to worry about me doing any drugs or drinking because I don't even do that. I don't indulge in that stuff. I honestly don't. Like, I could just man up and say I definitely was late on blowing through that breathalyzer because I just had surgery and my body was under it, and I kind of slept in a little bit too late. It was kind of like I had surgery on the 13th. They saying that I dropped late on the 14th, or I didn't even go on the 14th. I've been calling Mr. Abraham and telling him like my situations and everything, and we've been talking. And he told me, hey, you got one more chance not to go, and this and that. And I'm like, all right, I gotta go. So I actually paid some money to my auntie so she could take me to Jackson to get my breathalyzer thing out of the thing so I can blow, So that was on the 15th or the 16th. I'm not too accustomed with the dates and everything, but I honestly would say that I'm wrong for dropping late like that because I was trying to do everything right.
Have you ever had a dream have you ever had a dream that a dream and
with this breathalyzer and with the drinking and things. But today I was gonna come here and ask, I shouldn't even have to do that at least one time a week instead of 3 times anyway. But I didn't have any knowledge that I had any bond conditions, and I still would have came in here if I knew I had bond conditions anyway, just so I can, talk to the judge face to face anyway. But I'm asking, could you just give me a chance, man, to prove myself right and to not let this happen again? I'll do it 10 minutes early. I won't never be late. I always show up on time just to drop or anything. This won't never happen again. I can bet my daughter on it. I got a 16-year-old daughter. She's like all the way in my life 100%. And, just me and her. I'm just trying to take care of her family. Just trying to do the right thing every day for real. Since all this stuff happened. It's just been hard on me though, because of the surgery on the 13th. And then bit hard on having transportation and everything. It's just been kind of hard, but I've still been dealing with it. Yes, I'm done, man. I'm done. It's just a lot that I kind of want to tell you anything, and I just want to kind of get it off my chest.
I'll make sure you get it off your chest before I get done.
I'm done, sir.
So, I don't know your history, your past, or anything, but I think it's really, really important for you to understand who you're dealing with at this point. And I am a judge who is, I think, pretty laid back, soft-spoken, and thoughtful about what it is that I do. And I think that, again, not knowing your history or anything, but you're court ordered to do these things. As a matter of fact, you had to sign those orders before you were released when you were arraigned before, agreeing that you were going to do what it is that you were supposed to do. And even in spite of that, or despite that, you had a conversation with Mr. Locke where he said, hey, you gotta tighten it up, and you didn't tighten it up. Which is why you have more than one violation. He could have brought you in for any single violation. But instead, I've got 8 that I'm dealing with, because he didn't bring you in the right way, because he did give you an opportunity to show that you can tighten things up, which is something that we should probably have not done. We should probably brought you in just as soon as it was the first violation, because otherwise you don't think that it's really that serious. This serious. Your freedom, your ability to be able to live your life the way that you want to live your life is complicated by what it is that what's supposed you to do. Remember, these are not suggestions or recommendations from court orders. And one of the things that you have to think about, and this is the way I kind of think about it too, is that we didn't come to the court on a winning record, so to speak, that there had been problems. And that's why we have this case, that there's a problem. And so we're trying to figure out how to resolve that problem. But while we're trying to resolve that problem, you have to strictly stick to what it is, to what is ordered you to do. Again, not a suggestion, not a recommendation, but a court order. And if you're going to be with me for any sort of length of time, you need to understand that that is something that's written in stone. That I'm not going to yell at you, I'm not going to call you names, I'm not going to throw things around on my desk to try and intimidate you, but I will hold you accountable for what it is that I've ordered you to do. So it's time to be 100%. And we'll talk again on Thursday, but you'll get an opportunity to kind of think about what you're really and truly prepared to do, because it's easy to say, hey, there's a chance I'm going to make it right. Maybe you will make it right. I don't know you. But the history is that you already have 8 violations. So I'm a person who believes in strict adherence to court orders. So you get a chance to kind of figure out whether this is a point in your life where you're ready to turn things around. Say you got a young daughter, she's 100% your life. You need to be 100% on the beam, testing on files and say you need to be on balance with regard to your life and making sure you're taking care of everything, including your work responsibilities, so that you can be in your life 100%. And that's sitting in here trying to figure out how you're going to deal with the implications of having to deal with the court. You got things like certification.
That's why I was calling Abraham, and we were on good basis, but it was just hard trying to communicate with him through different things. And because at first they were going to say, hey, you can just drop 2 times a week. And I was like, oh, that's a little bit better than 3 times. So and then he called me back and changed everything up and kind of helped me more out. Abraham helped me out with saying, well, you got to drop 3, but or you can have the machine basically at your house. All you got to do is just wake up on time and to blow into the thing, which I thought was a little easier than I assumed. But the surgery, like I said, kind of had me a little sleepier when I'm waking up. So assuming I basically at like at 8:23, I'd rather just agree to it, man, than try to say like I was like in the right. And because on the box of pushing in a breathalyzer, it said a different time. And I'm not sure if it even said 8:23, but I thought it said a way different time than that. And I could have been wrong, But the surgery definitely had me a little drowsier than normal in my body.
You actually have a pretty good lawyer next to you. And I don't say that to flatter him. I say that as sort of a professional evaluation of having Mr. Nichols in front of me. For a lot of times, probably over 100 at this point. You should probably take advantage of an opportunity to speak with him. Because I think that I've said some things to you that he would want to sort of reinforce with you.
Yeah.
Because if you're going to be with me, it's going to be probably life altering. But you need to be able to have your mind right about what's important as part of this process. And I think that he can help you in terms of an understanding of how to approach this. Okay. Mr. Nichols, you have a moment that you can go back and talk to him. If not today, tomorrow, or whenever.
I can get over to the jail. This week. Okay. And if you clients have to go over there and speak this.
No, excuse me.
All right, we'll see you on Thursday.
Is like Thursday, if the bond's that high, I still wouldn't be able to pay it. You could just because of.
Well, you might actually be able to get out on Thursday, depending on our conversation.
Okay,
That's what we talk about. But you need to spend this time thinking about what it is that accepts you and what you're prepared to do.
Yeah.
Okay.
Sorry.
That's like law speak for naughty corner. While I see if he showed up today, I want to just hop over here. Judge, do you have sound? I like this judge. She reminds me of a school teacher.
I don't have any sound.
I don't think they have any sound. Okay. Oh, tomorrow is Thursday. Oh my gosh, I literally thought today was Thursday. But oh, I'm covering the judge. Didn't I also say yesterday, last night when I said goodbye, I'm like, I'll probably be at the dentist. That's tomorrow. Okay. No wonder she went live so quickly. One sec, one sec. One sec, one sec. It says that my browser lost audio.
We have so Ms. Collada, do you have some clients?
Your Honor, but I just signed on to the wrong Zoom. Why is that? Because my client's on Zoom. I was hoping to call Mr. Heath Scott. Right?
Okay, Mr. Heath Scott, are you on Zoom there? Good. Can you unmute?
Yes, I'm here.
All right, we got Mr. Heath Scott. We got trial scheduled for the 26th.
Plan today is that Mr. Heath Scott will enter a stipulated order of continuance. I believe it should be in the judge's report.
Okay, we'll go look. And there it is. So, Mr. Heath Scott, you're entering to resolve this being a driver under 21 after consuming intoxicants. To resolve this, you're entering essentially a contract with the county and with the help of your attorney, and you have obligations and they have obligations. Do you feel like you've had enough time to talk to your attorney about this to enter this agreement?
Yes.
Good. All right. And so it looks like your obligations here is you'd be on probation for the next 12 months. You'd stay clean and sober, stay law abiding, get an evaluation for substance abuse. Mute people, please. Everyone out there, mute your microphones. Bryce Dew, Mary Gales, Romero Cotto, mute your microphones, please. Keep your microphones muted, other than Mr. Heath Scott. That's who I'm talking to, and that's who needs to keep it open. All right. So, Mr. Heath Scott, in that 12 months, then you go through an evaluation for substance use disorder. If they think you need to do treatment, you do it. You do a victim impact panel, which is a separate program. And you do a Department of Licensing approved safe driving course, which could be done online. You understand your obligations?
Yes, I do.
Okay. Now, in this agreement are all of your rights to have a trial. Do you understand those rights?
Yes.
Okay. And you know that if you enter this agreement, you give up your rights to have a jury trial?
Right.
Is that your decision?
Yes.
Okay. All right. And again, if you go through these 12 months, then Ms. Collada, what's the result? Dismissal. All right. This crime would be dismissed if you complied. I have to go over with you what happens if you don't meet your obligations. So if you don't stay clean and sober, if you don't stay law abiding, if you don't get the evaluation, do treatment, the victim impact panel doesn't get done, any one or all of those, then you're brought back to court and you lose this opportunity for dismissal. You understand that?
Yes.
Okay. And then at that point, you're agreeing that the only facts the court should look at to determine your guilt to this crime are the police investigative reports. You know that?
Yes.
And if you were found guilty of this, remind me, is this a misdemeanor?
It is.
Yeah.
Yes.
All right. If you were found guilty of this, then the court could impose as much as 90 days in jail and $1,000 fine. You're aware of that?
Yes.
Okay. All right. But all that doesn't have to happen, right? With your doing your side of this?
Right.
Good. All right. Any questions about entering this agreement?
Nope.
Okay. All right. Well, I'm happy to grant this. And then I'm turning to the attorneys. There is no space on this. Oh, there it is.
It's
For
a little
me,
off kilter.
it is a lot of kilter, but it makes sense now. And of course, I have to date my business. All right. So I'm going to give you a deadline, Mr. Heath Scott, on when the court wants to see that. And the reckless driving, is this included in this?
That is, yes, Your Honor, and I don't know if the form says it, but the reckless driving is getting dismissed pursuant to the SOC in the.
Is it
defensive
dismissed
driving
today
course.
or
Yes,
it's part
yes.
of this
It's getting
agreement?
dismissed today.
Oh, okay. So the reckless driving is being, all right, I'll grant your motion, to dismiss that today. And, all right.
I'm torn between changing to one that's not so slow, because I normally watch this judge do small claims and that's fun. But let's see.
Right.
Yes, ma'am, absolutely.
Okay. Ms. Lesh, do you have any other cases, clients today?
I do not. I'll defer to counsel.
Okay. All right. Have a good morning.
You too.
Hello, Ms. Moore.
Good morning, Your Honor. I have a few matters to address.
Great.
Up first, if we could call Mr. Cole, who,
Tell us what time.
let's see, is
What is he
number one at
doing?
10 a.m.
All right. Mr. Cole's in the courtroom. All right. Mr. Cole, you want to come join us? And assistants, that's fine too. You can both be up here.
Oh, I think he's sweeping.
Mr. Cole, you can have a seat.
And Your Honor, my understanding from counsel is that there was a competency assessment in this case and that Mr. Cole has been found not competent and non-restorable.
Right.
This was Mr. Gaslin's case.
And so everyone's had a chance to review that evaluation. Mr. Fortunato, Ms. Moore, Mr. Fortunato, we're at the stage of, looks like dismissal, and no recommendation for 7105 evaluation, given the diagnoses.
I'm seeing that as well, Your Honor. With that, I'm asking to dismiss the case without prejudice.
Okay. I don't have any judgment. You're getting it. All right. So Mr. Cole and your family there, no further court dates. All right. So you're going to be
We're
done.
done?
We're done. I'm going to hand you piece of paper that says we're done, so just give me a moment.
Okay.
Okay. DUI is dismissed.
No, I'll get that piece of paper and then hand it to you.
Thank you.
Yeah. Problem. So your attorney is.
Right.
Oh, that's good to know.
All right, your next client or case?
Is there gonna be a?
Yes, it's coming on up.
But I can wait on that and call another matter at this time, certainly. If I could call Ms. Pollock, who's number 12 on the 9:30, present in the courtroom.
Ms. Pollock, why don't you join us?
That's those when you got fresh.
Okay, conference.
If you want to do it today, so dismiss the misdemeanor if you admit responsibility.
Look at the video he has, and he's going to be looking at a couple of.
If they completely. Really.
All right.
Sorry, Thurston was well.
14A District Court for County of Washtenaw, State of Michigan is now back in session. The Honorable Judge J. Clifford Simpson presiding.
You may be seated. Court calls the case of People versus Aaron Keller.
Ready, Your Honor. Conrad Silver on behalf of Pittsfield Township.
For the record, Your Honor, Joe Simon on behalf of Mr. Keller, station name.
Aaron Keller. Thank you.
We're here for arraignment, Your Honor. Waive formal reading and stand mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. All right.
And with respect to the pretrial, Your Honor, I've asked Mr. Siller to look at the video he has, and he's going to be looking at a couple other things. We're asking to adjourn the pretrial to see if we can come to a resolution.
Mr. Stiller, you don't have to do what he says. No,
Several discussions about the case.
you really don't have to.
Your Honor, if we could put it.
He tries that with me. Go ahead, what?
Could we have it on the 18th of September?
Sure.
Thank you.
During the matter to September 18th, 2024, 9 a.m. as your invite indicates. Alleged BAC in this matter.
0.085, consent blood draw, traffic stop for speeding, but no otherwise any bad driving.
Didn't think he wanted a warrant sticker. All right. Set the defendant's bond at a $10,000 personal recognizance bond. Standard conditions, including no assault behavior or possession of any weapons. There's to be no use of any alcohol, recreational marijuana, or any illegal drugs. All right. Thank you.
Thank you, Your Honor.
Calls case People versus Daniel Freeman.
Conrad Silver on behalf of.
Good afternoon, Your Honor. Dan Garrett on behalf of Mr. Freeman stepping forward. Dan, if you state your name.
Daniel Freeman. All right. City arraignment.
Your Honor, will waive reading and stand mute.
Defendant name waive formal reading, standing mute. Court will enter not guilty. But what are we doing today on this?
Your Honor, we added count 2 of double parking. Mr. Freeman is going to take responsibility to that added count 2 if you accept the admission. Move to dismiss the original charge.
That's correct, Your Honor.
Responsibility to the fact that on July 2nd, 2024, location of Ellsworth Road, Pittsfield Township, you double parked a motor vehicle.
Yes, sir.
Court will accept that admission of double parking. That being count 2, count 1 is dismissed. Fines and cost of $180. When can you pay that, sir?
Pay it now.
Pardon?
I can pay it now.
Okay, wait till you get up to the counter. I can't,
That's a good idea.
I can't make change. All right, pay it today. All right.
Thank you, Your Honor.
Have a good one. You can make change. Court calls case People versus Megan Perkins.
Counter and civil on behalf of Pittsfield Township.
Are they? Megan Perkins, Mr. Mays.
Yes, Your Honor, I'm here.
Yeah, I've got you, Miss Perkins. I'm waiting for your attorney to grace us with his appearance. Mr. Mays.
I have been in contact with him, Your Honor. He was gonna request an adjournment and get some information regarding his client. That will end up resolving the case.
Okay. I don't know where. Ma'am, what I'm gonna do is unless you have an objection, I'm gonna take the representation of the prosecutor that you're requesting an adjournment to get information to them. And so I'll adjourn this matter out. Do you have a problem with me doing that rather than waiting
Not
for
at all.
Mr. Mayor?
Not at all, Your Honor. Thank you.
I'll adjourn this to September 18th, 2024, 9 a.m. or as your invite indicates. All right, bond will continue.
Thank you, Your Honor.
ma'am. Calls case People versus Latoya Leverett.
Counter and civil on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Ms. Leverett.
Hello, Latoya Leverett.
Thank you, ma'am.
We do believe Ms. Leverett's license is still suspended. She has been trying to resolve a court order that had a garnishment that was suspending her license. It says that that portion is closed, but
What's closed?
I guess the garnishment against her. We thought that would unsuspend her license, but she did inform me it's still suspended.
When's the last time you checked, ma'am?
I checked last week, and when I went online, it said that it was closed, but I called up to Secretary of State yesterday, and they said that my license are still suspended due to the garnishment.
Right, hang on a second, let me check, because this is where. This one, that ended. This one ended. Yeah, there it is. Okay, so she has an unsatisfied judgment. So is the only place you've been, where'd you go? Ms. Leverett? Okay, there you are. Oh, it's the sun. Okay, I'm trying to figure out. Is the only place you've been to try to deal with this, the Secretary of State?
Yeah, and then I spoke with legal aid, and I was to set a motion, but I was told, I went to court and I was told I put in the wrong motion for it.
What court was that?
I believe, is it 14A? I believe it's Judge Barr.
Okay. All right. So
Well,
here's the thing. Do you know how much that judgment is?
I believe it's like,
pardon?
Go ahead.
I believe it's like 7,000.
Okay, did you try to get into, okay. Did you try to get into a payment plan with them?
With the garnishment people?
Yeah, right. It looks like it's AAA.
Yes, no, because I was trying to solve it because I was unaware of it. I just had found out about it when my license was suspended. Because I was served wrong.
And so you went to the 14A2 district court. What were you trying to do there?
I was trying to I believe it's a motion to set it aside, but I did a motion for the garnish or something like that. They said I put in the wrong motion for it.
Well, given her efforts, I think Mr. Siller indicated she can admit responsibility to double parking.
Okay.
That's correct.
You're gonna let her do that? Okay, so Ms. Perry, here's the printout of what. Yes, you may. So ma'am, I'll take your plea to the double parking. Get in contact with your attorney. I just gave her a document that lays out the case that's underlying the case that's garnishing you, or the garnishment and the suspension case. So that might give you some more information, okay?
Okay, thank you.
You're welcome.
So Ms. Leverett, what the prosecutor is extending to you, if you want to do it today, is he'll dismiss the misdemeanor if you admit responsibility to a civil infraction called double parking. It doesn't go on your driving record. It doesn't go on your criminal record. It's an $180 fine.
Okay, I'll go for that.
Okay. All right. Okay. And Ms. Leverett, do you admit responsibility to the fact that on May 24th, April 5th, 2024, at the location of Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, that you double parked a motor vehicle?
Yes.
Court will accept that admission. Count 2, count 1 is dismissed. Fines and costs of $180. When do you think you can get that paid?
In 2 weeks.
Okay. Get it to us by September 30th. I'll give it to the end of next month.
Okay, thank you.
You're welcome. You have a good day.
You too. Thank you.
Court calls the case People versus Rodney Muniz.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Muniz. I have not had contact with Mr. Muniz, Your Honor. I don't know if he's on Zoom.
You got him? I don't see him.
I have no
No.
explanation for his failure to appear today.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. I'll give it 10% privilege. That warrant will issue the 23rd. Court calls case People versus Donald Pittman.
On behalf of Mr. Pittman, who I believe is present via Zoom.
You got him? Donald Pittman. I don't have him.
Your Honor, I have not had a conversation with him this week, and I have been playing phone tag, and I did provide him with the Zoom information. I did expect him to be here. I do not have failure.
Bench warrant will issue for defendant's failure to appear. Bond $5,000. Give a 10% privilege. Warrant will issue immediately. Court calls case People versus Ryan Rawls.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Rawls, who stands to my right. Please state your name for the record, sir.
Ryan, Matthew Rawls. Thank you.
Thank you, Your Honor. Does Mr. Rawls currently have a valid license?
Yeah. Does he thinks he does? Okay, hold on.
Oh, sorry. I was looking at the wrong note, Your Honor. I apologize.
I don't have it. I don't think he does here. Do you think you do?
No, I don't.
No.
I have my hearing tomorrow.
Oh,
That's your-
okay. So you have with the Secretary of State?
Yeah. At 1 o'clock.
Okay. Do this then. Did they say in any of the paperwork that you got, how long it was gonna take them to give a decision on it?
No.
Okay. Here's what we'll do. Let me put you out to the 18th of September. Oh, and then
I will be out of town.
he's gonna be out of town. No, see,
I'm sorry.
This is when I ask, are you driving?
No.
Okay, no. I'm just gonna ask. You'll be out of town. How long are you out of town?
I'll be back on the 20th.
On the 20th. All right, let's do this. It may actually work out for us rather than you come back, do that. Is the next second?
Yes.
All right. October 2nd.
Yep.
Okay, I'll set it then. And let's hope it comes back. You'll have something by then or something. Okay? Okay, good luck to you.
Thank you, Your Honor.
Court calls case of the people versus Malaysia Roberson.
And right, so on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perry, have Ms. Roberson. Ms. Roberson, can you open the record, please?
Falasia Roberson.
Okay, do you have a camera?
Yes.
Thank you. Okay, where are we on this?
So, Your Honor, I'm gonna push my luck here. Ms. Roberson is also a case where this was the last.
No, I'm listening. No, go ahead.
So the court ordered that this was the last adjournment of the pretrial. She has been trying to get her license, but she is homeless. She's been staying with family and she's just been unable to get her license.
The financial part of it.
Right, she has to pay money to get it back, and that's preventing her from doing so. So this one is another one. If the court is amenable, we'd ask to set for final settlement conference. Again, with the understanding we're trying to buy her some more time to get her license.
This is what happens when you're nice. No, I know. This is what happens when I'm not. So I prefer to take the other approach. And people are gonna think you're gonna be nice all the time. Wow, there's like 50 billion adjournment.
Yeah.
Okay, that's an exaggeration, but still, there's a lot.
Been a lot, yeah. She does want to get her license. She's just been in a tough financial spot.
I'll do this for Miss Roberson. Because Miss Perny ran out of things for me to do. So I'm gonna do it for you, okay?
Thank you. I appreciate it.
You're welcome. Not you. Jury final settlement conference, October 18th, 2024 at 9 a.m. Jury selection, October 21st, 2024 at 8:30. Both of those proceedings are in person.
If I get it before then, do I just inform the court? Before
Get
that
what
court date?
before then?
Like
If you get
my
your
license.
license before then? Well, if you get your license before then contact your attorney. She'll know how to try to deal with it.
Okay, because I'm doing
Sure.
it before then.
Okay, all right. I think she was trying to get you time to do it.
Okay, I appreciate it.
But if you get it before then, let her know, because she'll probably try to set it for another jury trial. All right, thank you.
All right. Thank you.
I can't believe she did. After all those wonderful things I said. Yes, that's it. No more.
And you said.
No.
that's-
I did. I absolutely told you that.
I was like. well,
Court calls the case People versus Gabriel, is it Shawaka?
Conrad Siller on behalf of
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Shawaka. Mr. Shawaka, can you please state your name for the record?
Gabriel Shawaka.
I said it right. Oh, I'm amazed.
Yes, you did, Your Honor.
I'm proud of me. Thank you for saying so, sir. All right.
Mr. Shawaka recently paid off a number of tickets. Would the court be able to tell us the status of his license?
I have it right now is suspended. But when did you pay off?
So there was a number of tickets that I had that there was two different counties that my license was suspended in. I believe Wayne County and Plymouth. I paid off the Wayne County one about a month and a half ago, and I paid off the Plymouth one 2 days ago.
2 days ago. Okay, so hold on a moment. Let me pass it. I'm gonna have them run me another record because my record's from the 14th. So you did something after that. So it's printing. Oh, they're already running it. See, they can read my mind. Unlike Miss Perrony. Because if Miss Perrony could read my mind right now.
I'm like broken.
You know. It would be printing, but you broke it.
There you go. He's good.
Oh.
Drum roll.
What?
Give me a drum roll.
I'm not telling you.
Ugh.
I will tell the defendant. I'm not telling you. No. His license is valid.
So, Mr. Shawaka will admit responsibility to double parking today.
So I move that count two, double parking, Your Honor, and if you accept that admission, then move to dismiss the original charge.
Sir, you admit responsibility to the fact that on or about June 11, 2024, at Salt Trail in Pittsfield Township, Washington County, State of Michigan, that you did double park a motor vehicle.
Yes, Your Honor.
Court will accept that admission. Two count one is dismissed. Fines and cost of $180. When do you think you can get that paid?
So that was my other question. So I just paid like a boatload of money to get these tickets paid off, and I don't really.
How much is that?
Well, the first one was $548, and the second one was
No, it's okay. You really didn't have to give me a number.
I'm sorry, but I'm stressing out about all of this money that just had to go out in order to get my license reinstated. So that $180, I genuinely don't know when I'll be able to pay it. That's why I'm kind of, trying to figure out my best option here with that.
Stressing me out.
I'm sorry.
No, it's okay. It's okay. When do you think you can get this done? How much time you need? Because you worked this out and you got done what you needed to do. So I'll work with you.
Probably about a month, Your Honor, if that's okay.
Do a little bit better than that. Let me get it paid by Halloween, October 31st. Give you a couple months and a little change to get it paid.
Sounds
all
good.
right.
Thank you much, Your Honor.
Does that work for you?
Yes, sir. Thank you very much.
Are you less stressed now?
I am. Thank you very much for that. I appreciate it.
Because now I don't have to stress. All right.
Yes.
Thanks.
Thank you. Take care.
Congratulations, young man. Take care.
Thank you. Bye.
Court calls the case of the people versus, is it?
Your Honor,
Coran?
excuse me, I'm sorry. This is Donald Pittman. I was on there earlier and it wouldn't work. I heard y'all, but I couldn't talk. I'm sorry to interrupt you.
Really?
Yes,
Okay,
sir.
That was Mr. Pittman?
Yes, sir.
All right, so here's what we're gonna do. We're gonna mute you, or you need to mute yourself. We're gonna go get the file and recall your case.
Thank you. I apologize.
Yes, sir. Court calls case, people versus.
Wait. This is not a drill. We have Judge Conlon live.
No. Talk to the I said, present the powers and judge dismissed the case. With my advice. Yeah. I'll tell you something. Yeah, about 3 days. She told me the names and I called up.
We honor our sons.
Well, this is awkward. I never get this judge live. I never get to catch this judge live, and he removes the stream the minute it ends. Sometimes even like just before he's going to wrap up, he just cuts it. Basically, some of the people we watch in Judge Simpson's court then come here for sentencing, etc. So there's a lot of crossover, and like that public defender with the glasses, he's the one who was the not public defender, the district attorney, prosecutor. The prosecutor, he is the one who was the prosecutor in the veteran thing that I posted a few months ago. You'll also see a lot of the same lawyers from Judge Simpson's court, and that's Morgan Barroso there with the beige top on. Who else? Is that intern Ali from Simpson's court top left? Yes, probably, because they all work in the same area. I hope he starts soon, because otherwise we're just going to be sitting here. But like, I don't want to miss him being live. Also, this kid does not look like I would imagine him fitting in jail. It's such a weird thing to say, but oh, I can't even keep it on sound while we watch Judge Simpson because it's such a noisy court. Like, just a heads up, here it's coming. Now it's not noisy, but
You can call me or text me personally. It's cool, man. All right, man. We'll do that. Thank you. This needs to be with cool. Thank you.
that man's suit pants are very tight.
So right. Good. Here.
Okay. We can go back here and I'll listen for All Rise.
Is it Coranthila Silva? I got that all messed up, I know. And every time I look at it and it's like 50,000 letters and I don't know what to say.
Conrad Silver on behalf of Pittsburgh Township.
Assistant Public Defender with on behalf of Ms. Silva, who is present via Zoom. Ma'am, can you please unmute and state your full name?
Talia Violeta Silva Corona.
Whoa. Okay. I'll take her word for it. No, how do you say your first name?
Thalia.
Got it. Got it. Okay. All right.
Thank you, Your Honor. Ultimately, I am respectfully requesting an adjournment, probably with no final adjournment of this pretrial. I have had a conversation with my client's immigration attorney as recently as today, and I want to have a further conversation with Mr. Siller to talk about a potential resolution of this case.
All right. Let me adjourn this matter to September 18th, 2024 at 9 a.m. All right. So, thank you.
Thank you.
Court calls the case, People versus Ernesto Zuniga Alvarez.
Conrad Siller on behalf of the township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Zuniga Alvarez. Please unmute and state your name, Mr. Zuniga Alvarez.
Ernesto Zuniga Alvarez.
Okay, do you have a camera?
Yeah.
Oh, there you are. Okay. Okay. What are we doing?
We are here for a pretrial. We are
Good. I have a question. How is it disruptive? Oh.
Finally.
Oh, he was acting up anyway. Ellie. Emmanuel was acting up anyway. So they took him back to himself. Still won't do it.
Can you give me a motion?
So let's start today. Mr. Featherbridge, can you come here for a second? It doesn't look like the guy from Masters of the Air. What happened that I had a meeting with Ciele and she's trying to push me in. We'll start. We talked to Judge Conti.
Number 16 and 17. Francois 239 FC.
Your Honor, good morning, Jonathan. I haven't done behalf of the people.
Good morning, Your Honor.
Morning.
I did. Good morning, Your Honor. For the record, Your Honor, Raymond Burkett on behalf of Mr. Clark.
All right. So today is the defendant's motions. I think one is to produce Joshua Perry at trial. The other is to produce a res geste witness. Is it Undra Hunter at trial? I've reviewed the motions and Mr. is the response on behalf of the people. And what seemed to be maybe urgent doesn't seem to be quite so urgent because the trial isn't.
Your Honor, and it's also the final conference that the motion may now be mute. And let me tell you why. Because after speaking with the prosecutor, they have agreed that we have two motions. Yeah. They have agreed that Mr. Hunter is a raised gestile witness. He, the only eyewitness to this offense, and they have agreed to that he's a raised gestile, and they will produce him at trial.
Okay.
So
And he was here the last time we were in court. I met with him. I spoke to him out in the hallway. He was here. Okay.
So that discuss that motion.
Okay.
Now, I've also talked to the prosecutor about Mr. Curry. And what they've asked me to do is that after we have unsuccessfully tried many times, I guess my process server, from what I understand, has gone to the place several times. They cannot locate. They denied he lived in all that kind of crap. I shouldn't use crap though, but anyway.
Okay, I've heard far worse than this one. So.
The prosecutor has agreed that if I give them a subpoena, which I've already done, they will serve him to come to trial on our trial date.
Okay.
And if that's the case, then that motion will be mute if the prosecutor agrees that that's what's happening.
And we have sent, and let me just say, Your Honor, the responses were artfully crafted, not by myself, but rather by my compatriot, Nicole Hughes, who I have lots of faith in. So I want to give credit where credit's due. But we have sent the subpoena to our OIC. He was kind of like, what's all this about? But he agreed that he was going to attempt to do it.
We've got some information about where Mr. Perry might be located. We will do our best to accommodate this Mr. Burkett in serving that subpoena. I can't make any guarantees that it's going to be successful because sometimes people aren't always forthcoming with certain information.
Okay. Okay. And I think our trial is now moved to October 24th or something like that.
That is correct.
So should we set a final pretrial just to make sure we're good?
I'm fine.
Now moved to.
We will do our best to accommodate this Mr. Burkett in serving that subpoena. I can't make any guarantees that it's going
just to make
witnesses has been properly subpoenaed. I don't think there's a need for another free trial unless you're gonna do the right thing and dismiss the case.
Well, all right. Mr. Emmons' response to that.
Guess I could put the ball back in the court because resolve this case if we just got a plea, but
okay,
that's not what we're here for.
Okay. I don't mind not doing a final pretrial. We do need to get to your final pretrial order. Did we do that before because it was previously set? You have your voir dire instructions order.
I know that we filed our witness list. I cannot recall off my head if we've already submitted the instructions.
No, here they are. I'm going to give them to you then.
Perfect.
So get these before you leave, and I will not set a final pretrial. If there is a resolution of the case, obviously you can get that on the docket, and we'll go that way. And then if there's further need for court intervention, Mr. Burkett, file something, and we'll get you back.
Hey, we'll do that. Thank you. Thanks, sir.
The record can reflect Burkett, and we are good. Thank you.
Thank you, sir.
Okay.
If there's I might ask the court to consider adding an additional date if there's some conflict with other trials that might be scheduled that same day.
Yep.
But we'll be in touch.
Okay, that sounds good. Thank you.
Number 42, People versus Ryan, 24199.
Let me know ahead of time.
Assistant Prosecuting Attorney Rosa on behalf of the people, Eric Julian attorney on behalf of Robert Thompson.
Give me a minute. I'll be all your way.
Sorry, guys.
Ryan, if you want to sit over this way. Right.
All right, so we have the people's notice of intent to introduce evidence of other crimes or wrongs, and I have reviewed that as well as Ms. Julian's response to that and the people's response to the defendant's objection. So happy to hear highlights from either of you, but I've read everything you've submitted.
Your Honor, I would rely on the pleadings.
Okay.
Yes, Your Honor. I also need to briefly address the original motion in limine, which kind of triggered this whole process because I had a couple other brief things in there that weren't addressed by the people's notice that led to all the other pleadings. So you're in the original defendant's motion in limine, and it was designed to kind of trigger this process earlier rather than later. I was not trying to accuse the people of being late, but sometimes in cases like this, having rulings sooner rather than later can help to facilitate the case in a lot of ways. So I had requested in defendant's motion in limine any reference to allegations of prior domestic violence, any reference to allegations involving prior CPS investigations, and any reference to an emotional breakdown that Mr. Thompson had experienced 2 days later, and then separately having to do with firearms that were later found in a vehicle. The people did respond to that. Well, they responded to paragraph 10 of mine regarding the, I guess, timeliness of it. And that was their response. Again, I wasn't going for the timeliness so much as trying to preclude, references to these types of things. They did respond to the firearm part, but just not as to the CPS investigations or to the subsequent emotional breakdown. So regarding those, then the people did file their notice regarding 27B and 403. Obviously, this is focused strictly on references to allegations of prior domestic violence. The court is very well aware of the facts in this case and all the different arguments that we've made throughout. And I know that the court understands my position that these were allegations that were made subsequent that day when the complainant was asked, has he been abusive to you? She said no. And these were allegations that came subsequent to all of that. And these are, they were words that she said, as the court is aware. And I'm not going to try and rehash the whole argument. There were words that she said. There were words that she took back. There are no independent police reports or anything like that of anything that, just these are acts that she said, and then she took them back. And then she even, and I know that I use the word fabricated in my pleadings, but at the same time, I mean, it's essentially what she did. She tried to explain why she made those allegations to start with, that they were not true, and that she was trying to recant them. And that's just, she's, I don't know that she's been not allowed to recant them, but they've remained a central part of this case. This case is a felony R&O. Otherwise, this would be, a district court case. It got bound up on here because of a felony R&O. And it feels like because of these allegations that were made and then were recanted, and now it's become the subject of the whole trial. The whole trial is now focused on misdemeanor count 2, a 6-month misdemeanor, and it will bleed into everything else. It just, even the court, even this court or prior courts, hearing these allegations has been stunning for the courts to hear. And we've been arguing them, obviously, a few separate times in front of different judges regarding a contact order. And it's even prevented, and I'm not trying to accuse a judge of making a wrong ruling, but they're so substantial, the allegations, the words that were used and then taken back, they're so substantial that it has rendered this family with no contact, not even no non-consensual contact for 10 months. So I can only imagine the effect it would have on people who are not familiar with the justice system. Any of our regular ordinary citizens, we will need to pick 12 to 14, depending on alternates, who have never met Mr. Thompson before. Every defendant that sits at this table, they have never met the folks in this box before, and they have never met them. They don't know anything about anything. And just hearing these types of allegations, as to count 2, I believe will result in character propensity evidence. As to the other counts, as to the R&O, as to the A and Bs with, the folks that used to be his friends that were around him that day, and, none of them are friends anymore. But I think that if he's the type of guy to say that, and even if the testimony is, he didn't say those things, I made them up, I feel like the allegations even alone are so much more prejudicial than probative of what we're really doing here, that it will unnecessarily bleed into the other counts. So I have obviously made all my pleadings based on that particular evidence. Again, we object to even going into that area of evidence. Yesterday, I was thinking that in the event that the court believes that this satisfies all the tests, that it's not more substantially prejudicial than probative. Yesterday, I filed a motion to sever count 2, because that really seems to be the one sticking point regarding all this evidence, is just as to count 2. If count 2, and the people have not had a chance to respond to that, so I'm going to stop myself from even arguing it. Big feat for Erica Julian to stop herself. But to, if the court is going to allow all of this type of questioning of Christy Thompson, then we can hear that at a subsequent date after the people have had a chance to respond. But we do believe that on its base, that the trial will potentially result in a very unfair result for Mr. Thompson, not based on the evidence, but even just based on allegations that are not proven, not true, recanted, even go so far as to say it's fabricated. Nothing against Ms. Thompson. I have not held any ill will. Like, there's no ill will on this side of the aisle toward Ms. Thompson at all for any of the things that she said. It was a really stressful time last fall. But so I'm not trying to accuse her of wrongdoing or find herself in a position where she's potentially giving testimony that would be filing a false report. Like I'm not trying to go in that direction, but I am trying to give context as to what the allegations are, how they will affect our trial, and ask the court to exclude them.
Okay. Question for you, but also do you respond specifically to what was just placed on the record?
I was under the impression that we were not going to be touching the subsequent motion that was filed today. That was what was represented to me by Ms. Julian a few moments ago. So I'm a little blindsided by that, I will have to say. I did not have adequate time to respond to that motion or even thoroughly read it as of today. I was in Judge Kunke's court until 6.
We're not going to sever anything today. So
Thank
no
you.
worries. That's not on my, that's not, but specifically, so the motion in limine was previously filed and partially discussed.
Correct.
And now we're kind of back up on the follow-up to that, which is the objection to your notice. So, I mean, again, I've reviewed everything. I guess I don't have any questions for you, but so Ms. Julian, am I correct in sort of summarizing your arguments to those issues? Really, it's just those statements are so bad that no trier of fact should hear them? Because in essence, like I could flip back your argument to you and say, isn't it most appropriate that the trier of fact, not me, the jury, hears those statements and decides under examination and cross-examination whether, I mean, you know, recanted is a significant thing, but they were said, I think. And so to some extent, I don't know how that isn't a subject of cross-examination and how that doesn't necessarily become potentially a winning strategy for you at trial. But I don't know how I don't let that go to the trier under the statute. I mean, the statute's pretty clear, I think. So it's not even the 404B probative prejudicial. I think it kind of comes in under the statute.
Yes, Your Honor. I obviously 27B and 27C, any defense counsel that's been involved in any form of DP cases for any length of time understands the implications of the statutes and what triggers them. Under 27B, that one tiny 2-word if is so huge, which means that it comes in if it is not otherwise excluded under MRE 403, more as to whether or not something is more substantially prejudicial than probative. So that, I mean, overall, I agree with the court that, you know, I included the 404B analysis in the Vanderbilt, but I mean, I understand what the statute says. I just wanted to make sure that I pled everything.
And I get the if too, but again, that's if, like, even if it was limited to the MRE argument, like, it's hard to ignore that those weren't statements made 10 years ago. That, you know, it was the people were trying to admit something that was an argument 10 years prior. It was kind of contemporaneous. So while I understand your argument 100%, and I understand your positing that those were almost immediately recanted and that this has caused 10 months of, you know, separation, but I don't know that I don't think it's appropriate. So if I'm tipping my hat to you, Miss Julie, and I'm probably going to deny this objection, but I don't see how that doesn't go to the trial.
So my argument has been more, and I understandably so. I also in these pleadings, it takes me a lot longer to draft these. I hope they read well, but it takes a lot longer to draft them than probably it sounds. I really poured over whether or not this with Christy, the people's position with Christy Thompson, our position with Christy Thompson. I do understand the limitations that I'm under with the statute, which is why in my pleadings, I actually really focused on the fact that it bleeds into the other counts.
And I would be from I don't know, I can't preview what I may or may not do as it relates to a motion to sever.
Mm-hmm.
I've read it myself. So
yes, Judge.
But I mean, I don't know what's happening there. But if I were to endorse the argument that you proposed today, I think that's the solution. I'm not saying I do endorse it or I will endorse it, but I don't think I can block the test. I don't think that this is something that the statute permits me to block.
Yes, Your Honor.
So let me go ahead and just put officially on the record, kind of I'll do both matters in the sense of your prior motion in limine and then the people's notice. So as to the defendant's motion in limine, the motion is denied. Questioning the defendant's prior acts of domestic violence, CPS investigations, and his subsequent voluntary hospitalization are relevant and admissible under MCL 768.27B. And I know some of that was some of it was focused on the CPS stuff. So this was my prior analysis of the motion filed. The legislature has made a policy determination that in cases involving domestic violence and other acts of domestic violence are inherently relevant and admissible. So the motion in limine is denied. So the people's notice of intent to introduce evidence of the defendant's other crimes or wrongs pursuant to MCL 768.27B and or MRE 404B, the defendant's objections are overruled. The court finds that under MCL 768.27B, the other acts of domestic violence are relevant and admissible. So you now have a record on those two motions, or that motion and that notice.
Just to be clear, with regard to referencing of the firearms, is that also permitted and based off of your denial of the motion in limine?
Well, that was in the original motion. So I mean, I confess, I'm not clear what you were carving out today in terms of what you're arguing versus what the notice of intent did. So that was a couple weeks ago. The motion in limine was filed. I prepped for that, was ready to go. And now I don't want to muddle things by not addressing it correctly. So what's?
Yes, Your Honor. So I also included, Brian is a CPL holder. He turned in everything that he was required to as a result of this case. There were the firearms that were lawfully in his vehicle that day. I believe they're still being held by the sheriff department, not in evidence, but in property. Brian's asked me multiple times, and I've alluded to it, and and I put it in a pleading that technically those can be released to anybody. They're not in evidence, and they can be released to anybody. So I'm going to work on that separately. Here is the whole landscape of how the firearms and I understand Your Honor's rule, but I want you to just hear my entire
Don't give me
mindset.
the whole landscape. Just focus on what in response to the question.
I mean, very forest, very few trees. Okay. Here's what I'm concerned about. On that day, Ryan either did an act that constituted a resisting or obstructing or whatever under that umbrella. He either did that act or he didn't. In terms of assault and battery, he either performed an act that was criminal that resulted in an assault and battery, or he did not. In terms of Christy Thompson, again, this is all going to character propensity. I'm afraid that the jury is going to hear that there are even these allegations, and Your Honor has ruled, and that they will hear that there are allegations of lawfully held firearms that were in his vehicle. That was not something that was even brought up or discovered until after everything that was in the information is alleged to have already occurred. That was as they were seeking to either move his vehicle or clear things out. This was at the tailgate, right? And then it was like, oh, hey, so we just had like all this, brouhaha about, and I don't mean to minimize it. I mean, they had a 4-year-old missing child for half an hour. Everybody was freaking out. And I think it might've been a little bit longer than that if I'm going on body cam. Everybody was just really freaking out. So there's like this whole brouhaha. And then we get to the point where they see his lawfully held weapons in his vehicle, and they're like, oh shoot, we should probably take these out of here for a little while, either for safekeeping or
you
until
did just say shoot.
Shoot.
Push of exclamation. That's okay. Relevant to my.
I have a very dark sense of humor. I was not trying to display it on the record. And so, and then for her a week after the event, while all these allegations that she's making that we've been arguing about, she says, oh yeah, and I knew that he had guns in the car, and that's additionally why I became afraid. And that's the only way that these firearms become relevant in this case. I'm very concerned that the jury is going to hear allegations that have been made, recanted, fabricated, whatever we call them, along with statements about firearms that were in the vehicle that have, again, she's recanted this idea that she was afraid of him. That they hear all of that and they are like, oh, wow, he's exactly the type of, this sounds like the type of guy who's going to resist an officer. This sounds like the type of guy who's going to assault his friends. This sounds like and that's where I'm getting into the character propensity. Again, this may be a subject as to count 2, as opposed to the remaining counts, because he's not charged with any gun crimes, and none of these were factors in the other counts. And it only became a factor in count 2 a week after the fact, and it's been recanted. So that is the issue with the firearms.
Okay, Ms. Barroso, anything there?
Your Honor, the position of our office is that the firearms are extremely relevant. To count 2, one of the charged counts, it justified and exemplified why Christy was so in fear at the time when he threatened to kill her. She knew they were there.
Right. And so again, not to sort of supercharge this question of whether I'm going to sever count 2 or not, because it feels like I'm being kind of driven in that direction. I'm not making any determination on that today, but at this point, while all the counts are together in one petition or one information, how I would divorce the guns from anything else at this time. The statute does include that is relevant, and so I am not going to make any determination that the statements and or possession of the firearms would be somehow suppressed, or that's the wrong word, but would somehow not come in to the trier at this point. So maybe that is something that we consider in your motion to sever, but I'm not going to do it at this point. So everything I just said previously, I did intend to say. So I'm going to go ahead with that, and then I'll look forward to your motion. We did cancel the trial previously. Do we need a new trial date, or should we wait till this motion is determined? I mean, are you intending to get it filed so that it's heard in the next couple of weeks, or?
I'm sorry, I filed it yesterday. I did not, as Ms. Barroso rightfully pointed out, I did not even notice a hearing because I knew we were going to be here today. And I figured, we'd sort that out today. And so there were some emails this afternoon before the docket started. I believe Your Honor's next available date, I know that you are out next Wednesday, Judge, is September 4th. That would be the Wednesday before the trial. And so, to be frank, this has been so stressful for this side of the parties that I would not want to delay a trial any further.
All right, that's totally fine. So I'm going to give you your voir dire exhibit and pretrial order today, so you have that. And we'll schedule. I mean, I'll adjourn a final pretrial to September 4th, and then you can schedule your motion for that day, and we'll make that determination.
And then that date may also be operative. I know that our conversations between the parties altogether will continue about whether there is a way at all to resolve this case short of trial. And so that Wednesday will be operative in that effect regardless. So we'll see the court on that Wednesday.
All right. So I'm going to let you notice it though. I've adjourned the final pretrial to the 4th. You notice that. We'll take that up. I can tell you right now that's going to be via Zoom.
Oh, the entire docket?
Yep.
Gotcha. Thank you for the heads up.
Okay.
Okay, thank you. We'll be on Zoom.
Yeah. So you'll be at the hearing, but you won't have to be here.
Okay. All right. Thank you, Your Honor.
Okay.
So. Yeah, see you.
Number 47, People versus Jasmine Waters, 2466 F8.
David I. Goldstein, I'm bringing on behalf of the defendant. Ms. Waters is not present, Your Honor. I received communication. This matter before the court today for sentencing. I received communication from the probation department recently that they have been unable to communicate with her to get her interviewed and to get a pre-sentence report prepared. There is also a notation in that email that I received that they had unverified information that she was using drugs. I just mentioned that because it was there, and I'm sure Ms. Mullenbring will probably mention it if I don't. but I have no idea where she is. I've had no contact with her.
Goldstein, you know why this then sort of hardens my heart at these bond arguments.
I know, Judge.
So, all right, well, Ms. Willenberg, I'm guessing you're going to ask for a bench warrant.
I am.
And I will sign that upon submission.
Okay.
Thank you.
Number 8, People versus Cedric Castro, 24521 FH.
Good afternoon, Your Honor. Attorney Maxwell Dubin, P number 86012, on behalf of my client Cedric Castro, who stands to my right.
Yeah, thank you. Good morning, or good afternoon, Jonathan Emmons, again on behalf of.
Okay, gentlemen, today is the date and time set for a pretrial in this matter. Are we proceeding with any resolution, or should we set a trial, or what's next?
Your Honor, I do believe we will have a resolution. We just need a little more time. We're asking for a 2-week adjournment. I do think by that date, we will have a resolution, Your Honor. We have been in constant contact. Me and my client, he knows he'll be at every court date moving forward as well. I believe the prosecutor in this matter needs to talk to the officers, and I think we're all coming together here.
We have a couple options for a resolution on the table. I'm just gonna go through the officers, get their thoughts on the potential outcomes, and then hopefully we can figure this out.
How about we adjourn it to September 11th? Is that okay?
That works for me.
It works for me too, Your Honor.
Okay.
I'll make it work even if it didn't. So
Well, you said 2 weeks, that's the 4th. I'm trying not to load up that document.
that's fine.
Via Zoom, so I'd rather see your smiling face in person.
I'll take that, Your Honor. Thank you.
So see you back here on September 11th.
Thank you, Your Honor. To you and your staff. Hope you guys have a wonderful rest of your day.
Okay, thank you.
Have a good one.
Number 55, People versus Marcus Wright, 24547.
Assistant Prosecuting Attorney Maurice Todd.
And good afternoon, Your Honor. Robert Ellman with and on behalf of Mr. Wright. Mr. Wright, can you please state your name for the record?
Marcus Wright. Good afternoon. Today is also the date and time for a pretrial in this matter. So this is the first pretrial, so wondering what we're doing today.
Well, Your Honor, I've had a chance to talk to Ms. Barroso. It sounds like both of us would like some more time to put our heads together and see if we can come up with a resolution to this matter. So I'd be asking for an adjournment, potentially the 11th date if you still have space available.
We have space available anytime except next Wednesday.
Okay.
So, but it doesn't need to be on the 11th. If you think if you pick a date where you're pretty sure you're going to have put your heads together, we can do it. So I don't care if it's the 4th or the 11th or after that. You tell me when's best.
So I leave for my wedding and honeymoon. I'm actually not going to be here on the 11th,
Oh,
but
I'm sorry.
no, don't apologize. My thought is actually the 11th is just fine because
Someone else can.
someone else can handle it, but I'm free between now and then. So hopefully we'll be able to have conversations and I'll be around to actually do the negotiating and then somebody else, potentially Mr. Emmons can
I'm
actually.
totally fine with it. If you're comfortable with the 11th, let's do that.
That would be perfect.
All right, so we'll adjourn to September 11th, and we'll see you back here at 1:30.
Thank you, Your Honor.
Thank you, Ms. Brooke. Mr. Ellison. And Mr. Ellison.
Sorry about that. Congratulations.
Number 28, People versus Dewan McGee, 22750 FH.
Out in the hallway. Do you mind? Looks like Officer Wood is gonna, yes, help us out here.
On behalf of people.
And good afternoon, Camilla Barker. On behalf of Mr. McGee, who is present.
McGee, tell us your name for the record.
Juan McGee, Your Honor.
Okay. Today is the date and time set for sentencing. Are we ready to proceed on that?
We are ready to proceed, Judge. Mr.
Okay.
McGee, do you mind?
So, Mr. McGee, I'm going to ask but the lawyer can answer most of them for you. The first one that I need to start with is if you had enough time to speak with her before coming into court, you understand everything that's going on, you've gone over the pre-sentence report, are you ready to proceed today?
Yes, Your Honor.
Okay. It state for the record on June 12th, 2024, you pled guilty to counts 1, 5, and 6. The idea is that today counts 2 through 4 and 7 will be dismissed. And there was a sentence agreement for 1 year at Washtenaw County Jail with credit to be determined. So that's everyone's understanding, correct?
It is, Judge.
All right.
Yes, Your Honor.
Okay. So I have had a chance to review the pre-sentence report. I've had a chance to look at the guideline scoring by Michigan Department of Corrections. I'm going to hear from Ms. Barkovic as well as Mr. Emmons on that. I've done my own calculation too to come up with my best estimate. And so that all kind of goes into the mix as far as the sentencing is concerned. Before we get to the guidelines, though, let's just take the general narrative informational part of the report. Does either counsel have any objections or any additions, corrections, or deletions to the informational part of the report?
I do, Judge.
Okay, I mean, I've made the correction to the sentencing dates. You don't have to worry about that. But,
Thank you.
okay, go ahead, Ms. Barker.
So one major issue I have with the report is that it alleges that the defendant was on parole at the time of the instant offense. The report confirms that the defendant was discharged from parole on December 11th, 2020. The date that is listed in the report for the offense in this case is incorrect. The actual offense date was March 16th, 2021, which would be after he was discharged from parole in 2020. So there are numerous references throughout the report to offense date that need to be corrected. And then as it relates to his parole status as well. And ultimately that all impacts the jail credit that he's entitled to receive in this case.
Well, that's a big one, Ms. Barker. So, Mr. Emmons, would you agree that that is incorrectly stated in the report? I mean, that does have seemingly significant ramifications.
So I agree that it probably have some ramifications. I'm trying to bring up the charging document.
The charging document lists the wrong date.
Well, so are you talking about the information?
Yes, Judge, it should state March 16th.
10/27/2020.
And that's inaccurate.
Yeah, so it should be March 16th, 2020. Not sure where that.
Okay.
I know that this was an ongoing investigation, but the thing that he is charged with and pled to is a sole incident that happened on March 16th, 2020.
Correct.
There was an ongoing investigation that has been going on for some time.
So I've never corrected an information through a PSIR. So what do we do today to sort of analyze this? I'm happy to hear your, I mean, it is going to affect obviously jail credit, I assume.
It will.
Is that something that you and the prosecutor and probation are all going to be able to agree on the spot, or do we need to adjourn this to have the PSIR corrected so that it correctly reflects that?
Judge, I came prepared to address it today. I'll defer to the court.
You know that I can't just, I mean, as much as I'd like to, Ms. Barkovic, just agree with you.
No, I understand.
My only question is, I appreciate that you're ready to correct it, but are they going to be ready on the fly to sort of make the corrections and assert credit when we're here to sentence him? Because he's going to be remanded based on, I mean, unless he's got 365 days of credit.
He does not.
So
I understand that. I did come prepared with proof to essentially substantiate the claims that I'm making to the court. In addition, if you look at the jail credit section of the report, it indicates correct dates pretty much. There are a few minor modifications, but the biggest,
Approximately how much credit do you think he's gonna have?
my assessment is 171 days.
He's got about half.
Correct.
So it looks like, at least from what we have, is from the March date of 2021 to today, per exit jail, I'm looking over Agent Seibert's, or Seibert's shoulder here. 168 days within the Washington County Jail, and then 1 day within Year One Heights.
So that's close to what Ms. Barkovic just stated. And that's within a few days.
169 versus 171.
Will you stipulate to 171?
Will you stipulate to 169?
Would you want to split that difference?
Could we do 170? You okay with that? What? Huh? 1 day. Judge, every day matters in jail. Every day in jail is a bad day. My client maintains his position that he is entitled to 1 additional day credit.
Right, but so that really means that, and I'm okay with doing this, is I can adjourn this sentencing until this is corrected. I can't, you heard me, Mr. McGee, I can't just sort of say, yes, your lawyer's right, or no, they're wrong. If there's a discrepancy, we've got to get to the bottom of it, because you deserve that, for sure.
Yeah.
But if you're wrong, and it's 168 instead of 171, you're going to end up with 3 more days. So that's kind of how that works. And I'm not saying you were wrong, but.
No, I understand, Judge. That's fine. We can adjourn it and have updates made.
Mr. McGee, here's an odd question for you. No matter what happens, you're likely to spend some time in jail. I don't think you're going to come up with an additional half a year of credit. Do you want me to remand you today and start accumulating credit and then do the sentencing via Zoom? I don't have to do that. I think you're going to come back to court. I'm not worried about that. But if you want to start accumulating credit, you can then do it by Zoom, and then we can be good to go there. It's up to you.
I'm assuming you do not wish to be remanded today. He would ask for an adjournment.
Okay.
I don't have an objection to, however, they wanted to proceed on those grounds, and I recognize.
All right, so we'll adjourn this to September 11th. So, sir, just so you're not taken by surprise, Mr. McGee, so you're not taken by surprise. Like if I had sentenced you today, you would have been remanded today. So I'm just saying we're going to start it on the 11th. So you're going to come back on the 11th for sentencing, and you'll be remanded that day. So I'm not going to order that you report in 2 days, that kind of thing. I could do that now. Like if you wanted to get, I could say report by Friday. I'm not trying to make a deal with you. I'm just trying to offer you options. So if you want to come back on the 11th, you're welcome to do that.
Judge, we would like to come back on a new date. My schedule does not permit me to come here on the 11th.
Okay, we can come back on the 18th.
May I check my calendar, please?
Sure.
Thank you.
Probation, I don't need an entire new report. If it can just, whatever needs to be corrected, either corrected in the report and give me a whole new report, or Agent Seibert, if you just want to do a report sheet to correct it, I'm fine with that too. Okay, thank you.
Judge, that would work for me.
So we're adjourning this to, let me just confirm, I'm here on the 18th, right? September 18th?
So you get what he's saying, like if you wanted to turn this off into the 18th to start getting credit.
I understand. I don't think so.
That's fine.
But I love the option. It's wonderful.
Okay, see you back here on the 18th.
Thank you.
And 21, 22.
20 people versus Pierre Horgrove, 21,589
847. Yeah, that's within the
68.
Yeah.
And 62 is the same day.
Yeah.
Dearborn kids.
Okay.
Dearborn High School. Yep.
Ready, Judge. Portia Feaster, Assistant Public Defender, standing in for Mr. Hargrove. Mr. Hargrove, please state your name for the record.
Pierre Hargrove.
Good afternoon. Counsel, are we proceeding with a plea today?
We are, Your Honor.
All right. Mr. Hargrove, I'm going to ask you to raise your right hand to be sworn in.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. All right, you can put your hand down, sir. Mr. Feaster, you don't actually have to raise your right hand. You're good. Okay.
Yes, sir.
All right, so I mean, you can go ahead and recite it. I have information, I think, from an email that the defendant's gonna enter a no contest plea because of civil liability concerns, to an added count 4 felonious assault, and that counts 1, 2, and 3 will be dismissed at sentencing, and a sentence agreement to no upfront jail or prison. Probation to include sex offender assessment, and if recommended by probation, and other therapy is recommended by probation. Standard conditions, no requirement to register on the sex offender registry, and no delay or deferred sentence. So that's my understanding of what the plea agreement and the sentence agreement. Is that accurate?
It is, Your Honor.
That is right.
Okay, all right.
I
Go
would
ahead.
indicate one other thing, just so the record is clear and we're all on the same page, that we were set for trial on Monday, and that was adjourned at the people request because we learned of the victim's untimely death. But I did indicate to counsel, and I know that they have relayed this to their client, that there was a preliminary. So, matter, I would have motioned to move the court to proceed to the trial with the preliminary exam transcript. So we have reached this agreement on all of the parties are aware of everything that's going on.
Okay, I appreciate that. For the record, and I have had a chance coming into this to review the police report, so we can proceed with no contact.
Thank you, Judge.
So, Mr. Horgrove, that's a lot. I blurted out a lot. Ms. Reiser did as well. There's a lot of information there, but you understand everything that's going on today?
It's Hargrove, and yes, I do.
Okay. Did I not say Hargrove?
You said Hargrove.
Oh, sorry. My problem. My bad. Wait. What is it?
It's Hargrove. It's German.
H-O-R-G.
It's pronounced differently than it's spelled because it's of a different origin, American language. So that's why it's pronounced how I pronounce it.
Sounds like an A.
A, but it's an O. Yeah.
I thought I had just
nailed
it up.
No.
Phonetic
You read it how we would say it in America, but apparently that's not how it's pronounced.
All right. So, Mr. Hargrove, do you understand everything that's going on today?
I do.
Okay. And you ready to proceed?
Yeah, I guess so. I want to just get this over with, honestly.
Okay, well, I'm gonna have to ask you some hard questions today. So if you're not ready to proceed and you're not willing to answer those hard questions, we can't proceed. So if you're not ready to go, we can reschedule your trial. And as you've heard from the prosecutor, they're gonna move to admit the preliminary examination transcript as evidence. And I'm not saying what I would or wouldn't do, but I don't really see an objection from your lawyer on that. So what do you want to do?
Judge, I've spoken to Mr. Hargrove and to Ms. Rodriguez, who's been his primary contact on this file. And my understanding is that he wants to put this matter behind us all, resolve this case. He's thankful for the plea agreement that people have offered. He's prepared to take that. It would be a no contest plea, but he is ready to resolve this case. Is that correct, Mr. Hargrove?
Yeah.
Okay. So you're going to be pleading no contest to a crime. Do you understand what that means?
I do.
So you're not saying that you did the crime. You're just not objecting about the allegations made by the people. But one thing I have to ask you is you understand that no contest means I still treat it like a guilty plea. Understand that?
Understood.
Okay. So the record was, I just placed on the record what the plea agreement and the sentence agreement is. We have the PAC code, and the maximum penalty for felonious assault is 4 years incarceration and or a $2,000 fine. I'm not saying that's what's going to happen, but you have the right to be notified of what the maximums are. So you understand that too, correct?
Right.
Okay. So you heard the plea agreement, you understand it, and you're willing to go ahead. I believe you've answered that, correct?
Correct.
Okay. I almost always categorically go along with plea agreements and sentence agreements. You should know that that's an agreement between you and your lawyer and the prosecutor. It's not, I didn't agree to that. I'm not saying I'm agreeing to it, but there's no reason for me not to go along with those except for two. And I'll give you the two examples where sometimes I back away and don't allow those to go ahead. One would be that if you get into any additional or new trouble between now and the date of your sentencing. At that point, I could possibly say, you know what? I'm not agreeing to no jail, upfront jail. I'm not agreeing to no upfront Michigan, MDOC incarceration. I just won't go along with that. I also might not agree to dismiss the other counts. And you would have pled no contest to this added count, and you might not be able to take that back. You might not be able to withdraw that plea. I'm not saying to you that should scare you. It doesn't, it never happens. But I just need you to know that should you get a new charge, get into new trouble between now and the date of sentencing, that could happen. Do you understand that?
I understand.
Similarly, if I read your pre-sentence report, meaning your criminal background check, your community background check, and all that stuff that I get at the time of sentencing, if I read that and there's something so surprising in it or so shocking in it that I can't in good conscience go along with this, I may back out of it too. I'm not saying that happens all the time. In fact, it almost never happens, but it could. And you just have to have notice of that. You understand that too?
Understood.
Okay. Are you currently on probation or parole? Because that could be affected by this.
No.
Okay. Other than what's been stated on the record, has anyone promised you anything to get you to plead no contest?
No.
Has anyone threatened you in any way to get you to plead no contest?
No.
Is the decision to plead no contest yours to make, meaning you're not being coerced?
Yes.
Okay. You understand, because you've just told me all that you can't come back later and say, Judge, I did this because of a threat, or I did this because of a promise, or I was coerced. You understand that because you just told me that those were not a factor, that you can't come back later and tell me that.
Yes.
Okay. I have placed on the record that you are you're pleading no contest because of potential civil liability. Mr. Feaster, is that accurate?
It is, Your Honor.
Okay. I've told you the maximum penalties there. And so what I need to ask you now is that by pleading today, you're going to give up your rights to a trial and all the rights that come with that. And I'm going to go over them with you. So at a trial, you would have the right to be tried by a jury, to be presumed innocent until proven guilty, and to require the prosecutor to prove beyond a reasonable doubt that you are guilty. At a trial, you'd have the right to question any witnesses. You'd have the right to have those witnesses appear at the trial, meaning not hearsay or not on Zoom, they'd be here. And if you needed witnesses for your defense, I would order them. Last set of rights is that at a trial, you not have to testify, meaning you can choose to not testify, and that silence or that choice to not testify would not be used against you or held against you. On the other hand, if you wanted to testify, you could testify at the trial. You understand all those rights, and that by pleading today, you'll give them up.
Yes.
Okay. Couple of appeals rights. If you have a trial, you automatically can go to the Court of Appeals if you don't like the outcome. File the papers, the Court of Appeals takes the case. Because you're giving up the trial, you don't automatically get to go. You have to ask the Court of Appeals for permission to take the case. And they decide whether they're going to hear the case or not. I don't decide that. You give up that automatic right to appeal, the automatic appeal that gets you to the Court of Appeals. You understand that?
Yes.
And then sometimes things happen at a trial that give you new reasons to appeal. But because you're not going to have the trial, you give up the new potential appeals. Okay? That make sense? All right. I don't know if you're a U.S. citizen or not, but if you are not, a plea could cause the federal government to take action against your immigration status. That may or may not affect you at all because of your citizenship, but you just have the right to know that. You understand?
Yeah.
And sometimes, and some crimes, certain crimes have reporting requirements on the sex offender registry. That is relevant in your case, but part of your agreement is that you're not going to be required to register on the sex offender registry. So you just need to know that certain crimes do have that as a possibility. Do you understand that?
Yes.
Okay. As it relates to the added count 4 of felonious assault, how do you plead to that? That would be
no contest.
No contest. Thank you. Let me ask Mr. Feaster and Ms. Reiser, do you believe there's adequate information in the Ann Arbor Police Department police report dated or number 200037697 dated November 12th, 2020 to support the elements of the added count 4 of felonious assault?
We would ask that you find the elements of the higher charge pursuant to the court rule. I believe that those are established in the court to keep it felonious.
We would agree for plea purposes, Your Honor. We believe it's all there.
Right. I mean, so I think that I think there's information to support all of the charges in the police report. So with that, I think there's adequate information to find for the court's sake that the added count 4 is likewise supported.
Yes.
Is that an accurate restatement of what you asked me?
Yes. Thank you.
Okay, very good. Thank you. All right, counsel, any other promises, threats, or inducements than those disclosed on the record?
It's all on the record, Judge.
Okay, have I complied with MCR 6.302?
People are satisfied.
You have, Judge.
All right. I do find the defendant's plea of guilty is knowingly, understandingly, voluntarily, and accurately made. I do also, I am satisfied that there is a factual basis to support the finding that you are responsible for the offense of felonious assault, which is contained in the original information dated 12/9/2021 and then updated today with the added count 4, and I will accept your plea of no contest. Prior to sentencing, sir, you are going to need to do an interview with probation. And so in a minute, I'm going to tell you how to do that or where to do that. Mr. Feaster, do you want to be present for the defendant's interview?
I'd ask that Ms. Rodriguez be able to be present, please.
All right. So what's going to happen, Mr. Hargrove, is that after this hearing, you're going to take the elevator. You're going to leave your information there at the desk to let them know that you just pled. They'll set up a call, an interview for you to meet with probation. I'm going to rely on you to reach out to Ms. Rodriguez to confirm that she can be at that. And if not, you can reschedule it because otherwise it's not going to be possible for her to know that. So you're going to go down to the basement on the elevator, leave your information, do the interview, and then we'll be back here for sentencing on October 16th at 1:30. Okay.
One more thing, Judge.
Sure.
Mr. Hargrove has just been able to get this situation played out. He understands that he can have no problem between now and sentencing, but he is still on tether, and he has been for a couple of years now.
A few, more like 4 years, actually.
Trying to make sure that he's away from the alleged victim in this case. Hearing that she's deceased, he no longer has, I wouldn't think, a need to stay away from her. So I asked the court to consider releasing him from his tether, given those facts.
I'll hear from either the prosecutor or probation on that. I don't know enough about the other surrounding facts of the case, but
I
okay.
think there was also a failure to appear at one point throughout the proceedings, but I don't have an objection to the tether being removed.
Okay, we're trying to resolve this now, Mr. Hargrove. So I will order a modification to his bond prior to sentencing. I'm assuming it was a GPS tether.
Yes, Judge.
All right, Mr. Hargrove, you can report to community corrections to have that.
Today?
Sure, if you can get out there in time after stopping with probation. Sure. I mean, let me caution you though. I actually wouldn't say go today because there's probably some paperwork that needs to be reflected. And if you show up there before they get it, they're not going to do it. So I would say tomorrow we'll have all the paperwork. Okay. All right.
Hang in there.
All right. We'll get this done. Thank you.
Brian Lovett.
Okay. Ms.
Brian.
She's gonna send the email. He absolutely knows. So he'll be ready to remove it.
Surprise. And Hargrove, I'm like, wait.
Number 29, People versus Wheaton Mather, 24/5.
Assistant Prosecuting Attorney Morgan Barroso on behalf of people.
Good afternoon, Your Honor. Sam Bernstein with on behalf of Wheaton Mather, who's coming up.
Okay.
I was going to ask to approach, actually.
Okay. You don't really need to approach. I can stay for the record that I will disqualify myself in this matter because I know Mr. Mather. So I know well enough that it would not be appropriate for me to proceed as the judge in this case.
Okay.
So
thank you, Your Honor.
I'll file the appropriate paperwork. It becomes kind of a blind draw as to which other judge is going to get the case. So it'll be reassigned for approval.
All right, okay, thank you, Your Honor.
Sure.
1 second right there.
Yeah.
Number 4, People versus Caleb Brookshire, 24575 FH.
Good afternoon, Robert J. Kill on behalf of Caleb Brookshire.
Your Honor, Jonathan Emmons on behalf of the people.
You said, I'll just scoot over. You said that we were asking about if you would cancel the home confinement, she would remain on tether. Mr. Emmons and I are working out a potential plea agreement, but in the interim, you said that you would reconsider the home confinement this week, and everything's been going well. Kayla's here. She knows where the exclusion zones are, should she remain on tether. And so what we're asking to adjourn this, Your Honor, and we're asking that you drop the home confinement. She would like to work. She would like to be able to shop for necessities. She would like to be able to go to church on Sunday. And so we're asking you, Your Honor, if you would please consider that.
I'm happy to consider it. Mr. Emmons, what is your thought, or Agent Cyber? What do you, I mean, this is pretrial, so.
Right.
Agents.
So, Your Honor, I haven't, in the following week, it looks like not had any issues with Miss Brookshire, so that's a big positive. The exclusion zones that are being contemplated, again, I think I mentioned this last time, are really part of the 15th case, and I haven't checked to see what the status of those are. So, you know, she's going to have to abide by those conditions as well as whatever this court orders. So I'm not sure what it is, but if the court wants to, my biggest thing is making sure that she stays away from the victims of crime, right? And so I know that previously she's run into problems while on tether because of DoorDash or whatever she was doing. And so she's going to have to know where she can go and where she can't go and what that means. You know, if she's going to, I don't know how to DoorDash, but like if she's going to have to turn down jobs or whatever.
That's fair. Let me just interrupt you to say, you know, Ms. Brookshire, here's the risk. Like I'm going to do this today, so I'm not going to not do it. So I'm going to remove the home confinement thing. But what Mr. Emmons is stating, just so you hear it from me, is if you violate even by accident, like especially there are conditions from another court too, to violate that, I'm left with no real opportunity other than to keep you remanded or we go back to home confinement. So that's not, I'm not threatening you that like fully, like I just want you to know that your employment has inherent risk. You could all of a sudden your tether causes an alarm because you're in an exclusion zone. You just need to be very careful about that. Okay, I don't want to see you by mistake. So I will modify the bond then to remove the condition of home confinement. I'm going to keep any prior bond conditions regarding tether. So I'm going to, you know, again, I don't know what the exclusion zones are in this case. It's not something that I would manage, but community corrections will manage that. So whatever other cases or other restrictions are in place will remain in place, but I'll lift the confinement, home confinement. Okay.
Okay, thank you.
Thanks. Do we need to set another pretrial though?
Can we have a couple weeks, Judge, maybe September 4th, if that's open?
Sure. Are you ready to go by Zoom, Mr. Gilwell?
Am I ready to go by Zoom?
And that's going to be a docket on Zoom. Want to do it on that or the 11th when you're back here in person?
I'd rather do it by Zoom.
I'm not offended at all.
No offense.
Not at all. You don't want to come see me. We can adjourn this to September 4th. Do
you have Zoom capability?
Okay. All right. We'll be back here then.
Thanks, Judge. Judge, my client asked me a question. Does she need to go home right now due to the home confinement or is home? I mean,
so here's the deal, right? I mean, so I am not going to have an order to go to community corrections while I'm sitting here. So the fact of the matter is I would suggest she do that so that there not be some sort of violation this afternoon. but I will not, I mean, I'll get all the papers to them. So, you know, like, let's just say that she probably should go home till 6 o'clock tonight. Because let's just presume I get that order over to community corrections by the end of the day. That's the best I can help with.
She might not be in violation, but that doesn't mean that she might not get arrested if she's
Right.
not complying.
Right, and so, like, it's easy for me to say she's good until she ends up back in custody by mistake. Then we're back at this. So I would say that until, you know, at least the end of the day today, till tomorrow morning, I will.
Just stay home till tomorrow. And she.
Okay.
Did you remove his tether?
I did remove the tether, yes.
Number 40, People versus Sarah Thibodeau, 23-8 FA.
Your Honor, Jonathan Evans on behalf of the people.
Good afternoon, Jake Hill on behalf of Sarah Thibodeau. Judge, Mr. Evans informed me yesterday that the Court of Appeals is going to take up the case. Whether that means, what that means, we don't know. That on my motion. So what we're doing, what we're thinking is of adjourning the October 7th trial date.
Just that we just cancel it and maybe just get a new final pre-trial date while we're waiting for the Court of Appeals to do whatever they're gonna do.
Didn't we have, what you said October, wasn't it September 23rd?
Yeah, I apologize. It's September 23rd.
Okay.
I'm looking right at it.
So we'll cancel the jury trial for September 23rd.
Thank you, Your
Um, let's just go ahead and set another pre-trial, like mid-October maybe, and see how that's gonna, I don't know how quickly this will be taken up. I mean,
I don't think any of us do. We're all just shooting in the dark.
so mid-October. Oh, 23rd is good.
23rd.
So how about the 23rd of October?
Judge, I'm sorry.
It's not going to be via Zoom because I'm going to want to see the person.
I have two trials. One of them's gonna go on the 21st. Is there?
Why, yes.
16th would be better.
Mr. Emmons, how about you? How's the 16th for you in person?
I plan on being,
Okay.
until I'm told otherwise.
Me too. All right. See you all back here on October 16th. I want to say though, in the event that there's further appeals, I'm going to leave it to you two to stip in order adjourning this. There's no reason to come back for a pretrial.
Your Honor, there is the matter of the bond violation, which brings us here today, actually. We're scheduled right now. I'm saying that Ms. Thibodeau was arraigned on new misdemeanor charges. I've agreed with Mr. Kilowald to adjourn this bond violation hearing to kind of see how that case is going to play out.
Can we just move that to the 16th, Your Honor, of October?
Sure. And just so we're clear, so Ms. Thibodeau is to not go to the Meadowview Street apartment or no being around Ms. Bliss. Is that
Yes,
correct?
Yes, Your Honor. She was charged with assault and battery, Your Honor.
Right, but that's part of the arraignment. So just to confirm that, but yeah, I'll adjourn that too.
Okay, thank you, Judge. October 16th.
And if you bond conditions,
Number 54, People versus Shaquille Williams, 24.
Williams.
I'm sorry. Jonathan Emmons on behalf of the people.
Mr. Williams, can you hear us?
Yes, Your Honor, I can hear you.
Today is the date and time set for pretrial in this matter. Looks like we have a jury trial scheduled for October 7th. Is that correct?
That is correct, Your Honor. I've had to speak with Mr. Kilowald. I know that Mr. Kilowald has also been discussing with my colleague, Ms. Blanche, about this case. An offer has been extended. We're still exploring that. And I think what we're going to ask the court to do is maybe adjourn the trial date to December 9th.
Correct.
And then potentially schedule a final plea trial in between that date.
And it's 12/9, a good day. I'm sure. All right, so we'll adjourn the jury trial to 12/9. And final settlement conference, when should we schedule that?
I know that the 21st is not a good day for Mr.
Judge, can we make it the same day as Ms. Thibodeau's case was October 16th? I think we'll have an answer whether it's going to go to trial. There's going to be a plea by then.
Sure. October 16th at 1:30 p.m.
Thank you.
Thanks, Judge.
All right, Mr. Williams, you're all set. I'll see you back here on October 16th for a final pretrial, okay?
Okay, Your Honor.
All right, you're all set. Thank you.
I'll see you this weekend, Shaquille.
Okay.
People versus James Trussell, 23789 FC.
4 in a row.
My lucky day. I don't know why, Mr. Kilwell, you want to come to court, but whatever.
Yeah, thank you, Jonathan Emmons, on behalf of the people.
Good afternoon, Robert J. Kilwell on behalf of Mr. James Trussell.
Mr. Trussell, can you hear us?
Say it again, please, Your Honor.
You can you hear us?
Yes, sir.
Okay, today is the date and time set for final pretrial in this matter.
James, would you state your name?
James Trussell.
Yeah, today is the date and time set for a final pretrial in this matter. And I know that I came to the court and I was looking for a trial date, and the court was gracious enough to give me a trial date. I learned last week that my officer in charge is part of the shift bid process. So when you're bidding on shifts, a part of that process mandated that she take her vacation to our trial. I don't feel comfortable being able to proceed. She is a witness. Also, I would not want to try and proceed with this case without her. And I communicated this to Mr. Kilowald. So I'm going to ask the court to adjourn the trial date. And checking with the court reporter, I got a couple dates, and it looks like maybe December 2nd was the date that we were looking at. I know that's unfortunate, and again, I thank the court for giving me what I was asking for in terms of the trial date. I'm kind of here with egg on my face about that. But I'm going to ask for that adjournment of the trial date, and I think that we wanted to get a different trial date as well. Right there. Or a different final settlement conference. Sorry.
Well, Mr. Kilowald, what are your thoughts on it?
It's fine, Your Honor. This is a very serious and actually sad case between two friends. That being said, we've been working. I'm doing some more discovery on this matter. I'm just relatively new on the case, and I've talked to James about that at the jail yesterday. So we have no objections of adjourning the trial date for further discovery.
That was 12/2 or 12/4?
12/2.
12/2. Yeah, 12/2 is Monday. 12/4 is docket.
Right. So 12/2 at 12. December 2nd at 8:30 a.m. will be the jury trial. And when should we do the final pretrial in mid-November, like a couple weeks before?
I'm fine. To be honest,
If you reach agreement ahead of time, guys get it out. Please. Otherwise, we can pick a date and
November 6th.
If you want to do October 16th.
Yeah, Judge, can we just, Judge, I'm sorry, I opened my mouth before I looked at my book. Can we just go with October 16th again? I apologize.
You are killing me. You really just want to limit once like every.
That's the rumor.
I'll just lay down over there, Mr. Killawall, and you can start kicking me. How's that? So, Mr. Trussell, we're gonna have a final pretrial in this matter on October 16th. So we'll see you then, okay?
Okay, Your Honor, thank you.
All right, you're all set. Thank you.
James, I'll come and see you in a couple days.
Okay, thank you.
Is there more for you to linger and hurt me, Mr. Killawall? Break my heart a little more? Stop on my feelings? Trying to make myself vulnerable in this 2024, and you know.
I think we're gonna call that one last.
Because he won't be back here for 6 weeks, so it's okay. You can sit tight.
Number 12, People versus Melvin Cooley Klein, the 22.
Assistant Prosecuting Attorney Morgan Barroso on behalf of people.
Ready again, Judge. Torshio Feaster, Assistant Public Defender, appearing on behalf of Mr. Cooley Klein. Mr. Cooley Klein, please state your name for the record.
Melvin Cooley Klein, the fourth.
Okay, you can hear us okay, Mr. Cooley Klein?
Yeah.
Okay. Today is the date and time for a pretrial, counsel. What are we doing today?
Thank you, Judge. We were here a couple weeks ago, at which time the people reiterated their offer, which was for Mr. Cooley Klein to plead guilty to count 1. That would be under the Home Pupil Training Act. And
It's gonna happen, Mr. Feaster. I gotta write it down.
I'm sure this is what's gonna happen.
Oh,
But I'm just telling you where we stand.
all right. So go ahead then. So a couple weeks ago, the offer was that he plead guilty to count 1 under the Homes Youthful Training Act.
And count 3
Under
under the deferred statute.
right.
I spoke to Mr. Cooley Klein about whether or not he'd like to do that or seek to plead guilty to all 3 charges under the Home Youthful Training Act. I explained to him the risk about the possible additional felonies if he fails on probation. He indicates he will not fail on probation. So he's asking, Your Honor, to plead guilty to all 3 counts, and to seek HIDA on all 3 counts, Your Honor.
And as I recall, and you're under obviously no obligation, Ms. Barroso, you're not agreeing to that as a sentence agreement, but I might still do it. Is that clear?
Yeah, he's under the age, I believe, that the prosecutor has to agree to Holmes. It is a court decision.
Okay. So Mr. Cooley Klein, you're essentially asking me, or your lawyer is asking me on your behalf, to allow you to plead guilty straight up to all 3 charges, but essentially what's called a Cobb's agreement, an agreement with me that if you do that, I would sentence you under the Homes Youthful Training Act. Is that accurate?
Yes, sir.
Is that what you want to do?
Yes, sir.
Okie dokie. Raise your right hand to be sworn in.
It will be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
All right. Sir, you are coming before the court today. I just need to make sure you've had plenty of opportunity to speak with Mr. Feaster or someone in his office, and you understand everything that's going on. Is that accurate?
Yes, sir.
Okay. You're going to be pleading guilty to a number of crimes. Is that correct?
Yes, sir.
All right. And you understand that those crimes have certain, maximum sentence requirements, and I'll go over those with you in a minute. But I just want to go over with you the idea of the Cobb's agreement. So you're pleading guilty to the 3 charges with the understanding that there's an agreement between you and your lawyer and me, that if you do that, that I will not, I will sentence you pursuant to the Homes Youthful Training Act, which I'm, by the way, delighted and happy to do. So that's not a real big ask of me. I'm happy to do that because it's a great program. But I just want you to understand that that's kind of what's on the table, right?
Yes, sir.
If I go out of court today and change my mind and say I'm not going to sentence him under the HIDA program, you would have the absolute right to withdraw your plea. But if you get into additional trouble or something new happens between now and the date of sentencing, or I read your pre-sentence report and I'm so shocked by what I read there, it's possible that you've pled guilty to these crimes and I might not agree to the HIDA and you might not be able to withdraw those pleas. So on the one case where I just changed my mind you have the absolute right to withdraw your plea, and I won't object to that. But I just want you to know, in the other two cases, sometimes that's a possibility. You understand that?
Sir.
Okay. You are currently incarcerated. So the question, are you on probation or parole, has slightly different connotation, but I guess in theory, you could be on probation in another county or something like that. Have you talked with everyone about this so you know how this plea might affect your current incarceration or potential parole from that, and or if you were on probation, and do you want to proceed today?
Yes, sir.
Okay. Other than what's been stated in court, has anyone promised you anything to get you to plead no contest?
Oh, sir.
Has anyone threatened you in any way to get you to plead no contest?
No, sir.
Is the decision to plead no contest yours to make, meaning you're not being coerced?
Yes, sir.
Okay, you understand, because you just told me all of that. You cannot come back later and tell me your plea today was the result of any threats or promises or coercion that you're not telling me about. Is that fair?
Yes, sir.
All right. You are pleading to home invasion first degree, which, let me just give you the maximum there. And I'm not saying that's what's going to happen, but that's potentially 20 years incarceration and or a $5,000 fine, and it could be a consecutive sentence if there was other convictions arising out of the same transaction. Count 2 is interfering with electronic communications, and that is a maximum of a 2-year incarceration. It's a felony, 2-year incarceration and or a $1,000 fine. And then count 3 is domestic violence, which is a 93-day misdemeanor, meaning you could be incarcerated for 93 days and or a $500 fine. And this could be consecutive also if the assault was committed in a place of confinement. There's also DNA profiling samples to be taken. And it looks like in the domestic violence, there might be restitution. I'm not sure, that's not a maximum anything, but I'm just informing you of what's on the information. So you understand those maximum penalties, sir?
Yes, sir.
Okay. By pleading today, you're going to give up your right to trial. And at that trial, you would have had rights afforded you that I'm going to go over because they're important. At a trial, you'd have the right to be tried by a jury, to be presumed innocent until proven guilty, and to require the prosecutor to prove beyond a reasonable doubt that you are guilty. At a trial, you'd have the right to have any witnesses testifying against you appear. You would be able to question those witnesses, and if you needed to, for your defense, I would order witnesses to come in and testify for you. Finally, at a trial, you'd have the right to remain silent, meaning you could choose to not testify. That silence would not be used against you, but if you wanted to, you could testify at the trial. Do you understand each of those rights, and that by pleading today, you'll give them up?
Yes, sir.
Okay. Couple of appeals rights you're also giving up. Because you're not going to have the trial, you can't automatically go to the Court of Appeals. Meaning that if you had the trial and didn't like the outcome, you could simply file the paperwork and the Court of Appeals would take your case. Because you're not going to have the trial, you give up the automatic appeal, which means you have to ask the court for permission, and the Court of Appeals decides whether it's going to hear your case. I don't. So you give up the automatic appeal, and you also give up the claims to appeal things that sometimes happen at or after a trial. Because you're not going to have that trial, you're going to give up any new claims for appeal. Do you understand those appeals rights and that you're giving them up?
Yes, sir.
Don't know if you're a U.S. citizen, but if you're not, the court, the plea could cause the federal government to take action against your immigration status and seek to deport you. I'm not sure if that applies to you or not, and it doesn't have anything to do with me, but I just wanted you to know that that's possible. You understand?
Yes.
Okay, and then certain crimes have reporting requirements on the sex offender registry. This may or may not impact you at all, but you just need to know it's possible. You understand that?
Yes.
All right. Count 1 is home invasion first degree. Count 2 is interfering with an electronic communication device. Count 3 is domestic violence. How do you plead to each of those counts?
No contest.
No, I think
You have to
pleading
plead guilty, like we discussed. You have to tell the judge what happened. So you have to plead guilty in order to get the HIDE program.
Guilty.
All right. Okay, so you're pleading guilty on each of those 3 counts, correct?
Yes.
Okay. On or about April 1st, 2022, in the township of Ypsilanti, county of Washtenaw, state of Michigan, at or near 1434 Share Avenue. First of all, were you at that location?
Yes.
Did you enter a dwelling at that location without permission, or did you break and enter that dwelling?
Yes.
While you were there in that dwelling, did you commit an assault while entering in or present in or exiting on either Jaslena Clark and or Christian Coleman?
Yes.
And to your knowledge, were they lawfully present in that dwelling? Did they have the right to be there?
Yes.
Okay. While you were there, did you interfere with someone's electronic communications? Did someone try to make a phone call on their cell phone or reach out through their computer or their iPad or something like that? And did you prevent that or obstruct that or delay that?
I did interfere with the phone, but they weren't calling anymore.
You did, Mr. Cooley Klein, did you say you did interfere with the phone?
Yes.
Okay.
Okay. All right. And then while you were there, did you, again, make an assault or assault and battery upon Jaslena Clark with who was someone you had a dating relationship with? Is that accurate?
Yes.
And did that assault result in damage to her property or potentially to injure her in some way? Either or?
Yes.
Okay. I don't know, counsel, that was a lot, but did I satisfy the elements to each of those crimes with my questions and the defendant's answers?
Your Honor, I actually think we ran into a bit of trouble with count 2 because he said that they were not calling when he was interfering. He did say he interfered, but the elements of the offense actually state that they were sending, conveying, or delivering a communication through the phone. So if they were not calling, I just believe that there needs to be some record of either they were trying to send a message or a text or something, some form of communication while he was interfering.
So let's just drill into that a little bit, Mr. Cooley Klein. Did one of those two people say they were going to text or call 911 or do something with their electronic device?
No, sir.
So I'm going to ask you to explain what happened because I can't take the plea if the elements are not satisfied. So what happened?
All right, we were arguing. The phone was sitting on the bed. I picked it up, told her I'll throw it at the wall and break it.
Okay, and while you were arguing, did anyone say, I'm going to call the police, I'm going to text someone for help, I'm going to call someone for help, I'm going to do anything like that? Because the requirements for you to plead guilty is that I'll just read it to you, willfully and maliciously prevented, obstructed, or delayed by any means the sending, conveyance, or delivery of an authorized communication. So if they were not trying to use the cell phone or at least telling you they were gonna call 911 when you did that, then I can't take your plea. So I don't know what happened. I don't know what was said during your argument, but there had to have been some sort of statement made like, I'm gonna call the police, I'm gonna call 911, I'm gonna call the supervisor, I'm gonna call my brother, I'm gonna call for help or something, because otherwise that's not an accurate plea. So do you need to think about that? Do you want to talk to Mr. Feaster about that? It's hard because you're not here in court, but.
Yeah. Well, it was made, they said that they were going to make a call, but that was after I already said I was going to throw the phone. So I already had the phone in my possession.
All right, let's see if we can get it this way. Did you know it was either Jaslena's or Christian's phone?
It was Jaslena's.
You had it in your hand?
Yeah.
And during your argument, did she demand that you give her back the phone?
Yes.
And during that argument, did she say, I'm going to call the police, I'm going to call 911 or something like that?
Yes.
And then what did you do to the phone?
That's when the altercation escalated, and then She was on my back and I pushed her off my back.
What
did you
about
do
the
with the
phone? What'd you do to the phone?
It was still in my hand.
And then what did you do with the phone?
I had it in my hand until like a second before I got arrested.
Okay, so you did not give it back to her. You obstructed her being able to get her phone by keeping
Yes,
it in
sir.
your hand.
And then I
Yes,
think
sir.
you said you threw it against the wall and smashed it, right?
No, I didn't throw it against the wall and smash it. I dropped it on the floor right before I got arrested.
Okay, but you had it until you so you never gave it back.
Yes, sir.
Okay, Ms. So I have no idea. That was a long.
I think that satisfies it. He kept.
Okay, all right. Either counsel aware of any promises, threats, or inducements other than those disclosed on the record?
No, Your Honor, thank you.
It's on the record, Judge.
Have I complied with MCR 6.302?
Yes, Your Honor.
You
thank
have,
you.
Judge.
Okay, I do find the defendant's plea of guilty is knowingly, understandingly, voluntarily, and accurately made. I also find that there is a factual basis to support the finding that you are guilty of the offenses of first-degree home invasion, interfering with an electronic communications device, and domestic violence as contained in the information that is in the court's file and dated June 14th, 2022, and I will accept your plea of guilty. Sir, you are going to need to do an interview with Department of Corrections prior to sentencing. They will reach out to you to do that interview where you are. So at this time, Mr. Feaster, do you want to be present or participate in that?
No, thank you, Judge.
All right, so sentencing in this matter will be October 2nd at 1:30 p.m. So Mr. Cooley Klein, our probation department will reach out to you through MDOC, okay?
Yes, sir.
All right, you're all set, sir. I'll see you back here in early October.
All right, thank you.
Thank you, Judge.
Okay. Collections. How about that? The new system.
Number 36, People versus Montez Smith, 21410 FH.
Good afternoon, Your Honor. Scott Featherbridge, Collections Coordinator, and today's the date and time for a collection show cause hearing for Mr. Montez Smith. Delinquency notices and subsequent show cause notices were mailed to Mr. Smith's last address. I spoke with him on August the 5th, and he was going to make a $50 payment by August the 12th. Unfortunately, I've not heard from Mr. Smith since then. He has made no additional payments. So I have no report as to his whereabouts at this time.
Okay, for the record then, is Montez Smith or anyone representing him in court today? No response in the courtroom, none on the Zoom hearing. Mr. Featherbridge, would you like a bench?
I respectfully, yes, Your Honor.
5 minutes.
Thank you.
Number 46, People versus Darius Tucker.
Good afternoon, Your Honor. Scott Featherbridge, Collections Coordinator, and today's the date and time for a collection show hearing for Mr. Darius Tucker. Once again, delinquency notices, subsequent show cause notices and orders were mailed to Mr. Tucker's last address. I did leave him a voicemail message on August the 19th with all of the show cause information. Unfortunately, I've not heard from Mr. Tucker and have no report as to his whereabouts at this time.
Is Darius Tucker or anyone representing him in court today? Seeing no response, none on the Zoom call. Mr. Featherbridge, would you request a warrant?
Respectfully, yes, Your Honor.
Need to make sure that's for Darius Tucker and not Darius Rucker.
Yes, Darius Tucker, no Rucker.
Okay. I'm so funny. All I can do sometimes is amuse myself.
I only want to.
Hold my hand.
That's the.
Number 39, People versus Sullivan, 23146 FH.
Your Honor, Jonathan Emmons on behalf of the people.
I'm sorry.
No, Mr. Smith, you are done.
Good afternoon, Your Honor. Robert J. Kill on behalf of Jeremy Sullivan, Your Honor. Your Honor, today's time of day for pretrial. I met with Jeremy at the jail yesterday. Judge, this is a case from 2021, at which time he would have been eligible for prosecutor's adult hideout. Mr. Evans has been gracious enough to say if he pleads to that, pleads to one of the counts, count two, identity theft, that he could plead under the adult hideout remains in effect.
Okay, is that what you hope to do today?
Yes, Judge, and I informed Ms. Count 1 is going to be dismissed. However, there is a $307 restitution owed, and I explained that to my client, that would be part of the plea agreement, so he's agreed to that on Count 1, even though it's being dismissed.
Okay. Mr. Sullivan, can you hear us?
Yes, I can, Your Honor.
All right, and you heard what Mr. Killawall just summed up on the record?
Yes, sir.
Pleading guilty to count 2, the identity theft, and then count 1 would be dismissed at sentencing. There's not going to be an objection by the prosecutor for eligibility to be sentenced under HIDA. Is that accurate? You understand that?
Yes.
Okay.
Judge, I'm sorry to interrupt. There's also one other thing, which I believe Mr. Evans is okay with. Currently, he has a PR bond with Tether. No, we're asking for a PR bond without the Tether, so several other communities can come and pick him up, and he can deal with several other issues, most notably in Lenawee and Oakland County.
Well, how would Tether interfere with that?
If he's on Tether, the Oakland County won't come and pick him up. That's it.
Okay.
Your Honor.
I'm 1 second old when I heard that.
Jeremy, can you explain that better?
Actually, Washtenaw County does not give tethers to people that have holds. So since I have a hold out of Lenawee County and Oakland County, they will not put a tether on me, so I cannot leave. Because you were the one that gave me the PR bonds with tethers.
Well, if I gave you, all right, I'll bite. If I ordered the tether, how would then we get the tether on if I don't have it put on? And then you go to those, let's say you go to Wayne or Lenawee first, and then you go to Oakland and you get released. What happens next? You're either violating my order, or well, how do we get the tether on if that's what I said I needed?
I've been sitting in jail this whole time. That's why.
Judge, would you consider a no tether on this matter?
I'm happy to hear anyone else's thoughts on this. So this is pretrial, so I guess that leads it to.
Again, I believe they're old cases, and not to minimize it, they're still cases, but this is from 2021. And he, at this point in his life, he would just like to get everything straight and move on to become a productive citizen.
What does Mr. Emmons think?
So, Your Honor, just to kind of get into some of the history, back when Mr. Feaster had this case in 2023, there was a point where you had ordered him to be on sclam tether, and he didn't get that done, didn't appear for court, and so he failed to appear. And then it looks like he might have been transferred to another facility. He kind of got lost. I think he got lost in the system of different holds and transfers to different places. And then we came here earlier this month, and he was released on both the DPS and the scram tether. We kind of talked about this previously. I can't say with any specificity about why he would or wouldn't get taken on a PR bond with tethers or not. Like I don't. Or
What's actually fascinating to me is I think we're in the middle of a plea, and why are we talking about bond at this moment in time?
That's true.
So I am happy to discuss this with you and work it through, but are we going to resolve it by plea today or
Yes,
not?
yes, Your Honor.
Okay, so let's get back to that. Mr. Sullivan, you understand everything regarding the plea, is that correct?
Yes, Your Honor.
Okay. And that there is this sentence agreement with the prosecutor to not object to you be sentencing under HIDA. So that's great. And I would absolutely go along with that unless you get into more trouble or new trouble between now and the day of sentencing. And then I might not. So you need to be aware that while you have pled guilty to something, what happens if I don't go along with that because of the new thing, or I read your pre-sentence report and there's something so shocking in it, and then I don't let you withdraw your plea. So I'm not saying that would happen, but you just need to know it's possible. Do you understand that?
Yes, Your Honor.
All right, so there are holds in other counties. I don't know if that means you're on probation in other counties or you might be on parole, but if you are, do you understand how this plea could affect those
Yes, Your Honor.
Okay,
Yes, Your
you
Honor.
still want to go ahead today?
Yes, Your Honor.
Okay. Other than what's been stated in court, has anyone promised you anything to get you to plead guilty?
No, Your Honor.
Anyone threatened you in any way to get you to plead guilty?
No, Your Honor.
The decision to plead guilty yours to make because you are not being coerced.
Yeah, yes.
Okay, do you understand that because you just told me all that, you can't come back later and tell me that your pleas today, or the plea today was a result of threats or promises or some sort of coercion that you're not telling me about. Is that fair?
Yes, Your Honor.
Okay, you are pleading guilty to that count two. So my job is to identify the maximum penalty there. That is a felony punishable by up to 5 years and or a $25,000 fine. And it could be a consecutive sentence if there's another conviction related to the identity theft. So those are the maximum penalties. You do know that restitution and the other count is also still on the table. So those are the maximums. You understand that?
Yes, Your Honor.
Okay. If I accept your plea of guilty, you're going to give up your right to trial. By giving the trial up, you give up certain rights that you would have. I'm going to go over some of them. At a trial, you'd have the right to be tried by a jury, to be presumed innocent until proven guilty, and to require the prosecutor prove beyond a reasonable doubt that you are guilty. At a trial, you'd have the right to have any witnesses testifying against you to appear in person in front of you. You would be able to question those witnesses, and if you needed witnesses for your defense, I would order them to appear. Finally, at a trial, you'd have the right to remain silent. In other words, you could choose to not testify. That silence would not be used against you. If you wanted to, you could testify at the trial. Do you understand each of those rights and that by pleading today, you'll give them up?
Yes, Your Honor.
Okay. You understand that if I accept your plea, you are going to give up a couple of appeals rights, meaning that sometimes a couple of things. One is, if you didn't like what happened at the trial, you could automatically go to the Court of Appeals just by filing the paperwork. That will go away by entering the plea. It doesn't mean that you can't appeal it. It just means that you have to ask the Court of Appeals for permission to take the case, and that court decides whether it's going to hear your case, not me. So you give up the automatic appeal. You also give up the claims to any new things that might have come up at or after the trial that might give you other grounds to appeal this. I'm not saying that that would happen, but I'm just letting you know that if you give up the trial, you give up these appeals rights. Do you understand that?
Yes, Your Honor.
Okay. I don't know if you're a U.S. citizen, but pleading today could cause the federal government to take action against your immigration status and seek to deport you. That seems like a huge deal, but it may not even apply to you. But you just have the right to have the notice of it. Do you understand that?
Yes, Your Honor.
Okay. Certain crimes have reporting requirements on the sex offender registry that may or may not impact you at all also, but it does have a possibility. You know that. Is that accurate?
Yes.
You understand that?
Yes, Your Honor.
Okay. As it relates to count two, which is identity theft, how do you plead to that?
Guilty.
Judge,
Okay.
may I voir dire?
What?
May I voir dire?
You may. Even though you don't like to come see me in court.
Judge, if you have a benefit, I'll come to that. Mr. Sullivan, on or about September 20th, 2021, in the city of, in Ypsi Township, County of Washtenaw, State of Michigan, did you possess, did you take Cassandra Lamont's social security card?
Yes, I did.
Did you have permission to take that card?
No, I did not.
And what did you do with that card?
I applied for auto loans.
And you did not have permission to do that from Ms. Lamont?
No, I did not.
And as to the count one that will be dismissed at sentencing, you agree that you rang up $307 in restitution, and that will be part of your sentence agreement to repay that restitution?
Yes, sir.
No further questions, Your Honor.
All right, counsel, you believe the elements of the offense found in count 2 of the information that's in the court files have been fully covered by the defendant's answers to Mr. Killowald's questions?
I believe so, Your Honor.
Yes, Your Honor.
Either of you aware of any promises, threats, or inducements other than those disclosed on the record?
Yeah, the only other thing I'll add is, it's not a promise or a threat or an inducement, but I did put on my form that I'm gonna be recommending to the court that at the time of sentencing, you include a recommendation for a substance abuse assessment. I don't know where he's been or what's going on with him, but I think that might be recommended. Not obligating the defendant to it, it's just a recommendation. That's the only other thing that I'm aware of. Everything else has been on the record.
Okay. Have I complied with MCR 6.302?
Yes, Your Honor.
I believe so.
All right, I find the defendant's plea of guilty is knowingly, understandingly, voluntarily, and accurately made. I'm also satisfied that there is a factual basis for the finding that you are guilty of the offense of identity theft as contained in the information that's in the court's file, and I will accept your plea of guilty. Sir, you are going to need to do an interview with probation prior to your sentencing. Mr. Killowald, do you want to be present for that interview?
Your Honor, I don't think that's necessary in this
All
matter.
right, so Mr. Sullivan, you're going to be released and you're going to need to contact probation once you are released. I don't know what the holds mean in the sense that you might be sent to Lenawee, you might be sent to Oakland, but if you're going to take care of those matters in short order, as soon as you're released from some custody, you got to report to probation within 24 hours. So you got to have that appointment. You're not going to have that appointment in 24 hours, but you're going to set up the appointment with probation. You understand that?
Yes, sir.
All right. I don't know about this bond thing, so let me tell you what I'm going to do. I'll order that the defendant be released on personal recognizance from the Washtenaw County Jail on this charge so that he can be released. I am going to order that when you are done with Lenawee and Oakland, that you report to community corrections, because it's not sentenced yet, for a scram tether so that we have that in place when we go to sentencing. I'm not saying you're going to keep it on, but I don't know what you've been doing the last couple of years, and that was previously ordered. So I'm going to let you take care of Lenawee and Oakland. When you're done with those two things, I expect you to report to community corrections, get that scram tether on, and then if everything is good to go, I won't order you continue it. I mean, I might order the substance abuse evaluation as requested. I don't know. We'll see what happens in sentencing. Does that make sense?
Yes, sir.
Okay.
Thank you.
So bottom line, Judge, the scram tether is off now until he deals with the other counties.
Right.
Okay.
So
And GPS.
whatever tethers, I'm not ordering that he continue those. I'm ordering that he report for a scram tether once he's done with Lenawee and Oakland County, and then we'll deal with anything after that.
Okay. And Judge, I know, but the plea was taken under adult height.
As I think so, yeah.
Okay, thank you.
Pretty sure we talked about
I think so.
All right, thanks, Judge.
So sentencing in this is going to be October 16th, 24. Here's the deal though, like that becomes a fictional date. If you're in Lenawee for 10 days, if you're in Oakland for 14, then we're not going to have time to do the PSIR. So I'm setting that. Mr. Killowald, if that happens, you got to let the court know to adjourn the date once he gets his appointment with probation.
I will track him down.
Okay?
Thanks, Judge.
All right, thank you. You're all set, Mr. Sullivan.
Thank you, Your Honor.
Number 15, People versus Brian Finneran Jr., 24615 FH.
Afternoon, City Attorney General Emmanuel Wutokoku, on behalf of the people.
Ready, Judge, Torshio Feaster, Assistant Public Defender, Mr. Brian Finneran, who should be on Zoom, Your Honor.
Mr. Finneran, can you hear us?
Yes, sir.
Say it again, Mr. Finneran, I think we can hear you.
Yes, sir.
Okay.
Thank you, Judge. Next time for pre-trial in this case. Mr. Finneran is trying to get this matter resolved. It's going to require some payments on his behalf. He's still working on collecting those resources. I believe he's requesting an adjournment, maybe about 6 weeks. And hopefully he can have some resources to pay down some of these financial obligations.
Before I turn this matter over to Mr. Whitaker for his input, letting you know we don't have fingerprints in this file, so you should be aware of that. So I'm okay with adjourning this if you are.
I have no objection, Your Honor.
Like, how far out should we go? Like a month? You said 6 weeks? 6 weeks would put us in September 25 or October 2. Do we have a preference for either of those dates?
I'll defer to defense counsel, Your Honor.
I was just checking to see if he was here either of those days, but if
I don't know.
okay.
Right, that's true.
Yeah.
I mean, obviously, I have lots of the feels with Mr. Killawall not wanting to come in here, and I don't need it from you too.
I'd have to check.
October 2nd, okay with me? All right, we'll see you back here on October 2nd at 1:30 p.m. Okay?
All right, thank you.
Thank you.
Supplemental number 4, People versus Austin Butler, 22744 FH.
Masters of the year. Your Honor, Jonathan Evans on behalf of the people.
Ready again, Judge. Torshio Feaster, Assistant Public Defender, appearing on behalf of Mr. Austin Butler. Mr. Butler, please state your name for the record.
Austin Butler.
All right, Mr. Butler, can you hear us?
Yes, Your Honor.
All right. Today's the date and time set for a violation of probation hearing. Looks like you were arraigned before Judge Slay a couple of days ago. So are we proceeding on the violation hearing, or what are we doing today?
Not proceeding, Your Honor. I did speak to Mr. Butler this afternoon by Zoom from the county jail. My understanding that the violation, unless there's something added that I'm unaware of yet, was based on some new charges that have been charged in 15th District Court and his failure to do some programming. My understanding is those charges in 15th District Court have since been dismissed. And so at this point, I think I'm seeking an adjournment for 2 or 3 weeks to see if we can get a new recommendation based on that case being dismissed. And I believe Mr. Butler wants to address bond, Your Honor.
Okay, so 2 or 3 weeks puts us to September 11 or 18. What would you prefer there?
Unless Mr. Agent Cyber has something to say. I saw you stand up.
PD, I believe, and the new charge is coming.
Oh.
Okay.
Well, see, I'm glad I had him go first.
So we maybe go to the 18th.
Yes, Judge. And I was gonna ask for a bond, but based on that, Your Honor, I would hold off on that request at this time. I'll follow up with Mr. Evans to see if that in fact does get charged in the next couple of weeks. If it does not, then I will ask Mr. Evans to consider doing a stip in order with me to change the bond in this case.
Sure, and you also could do it by Zoom on the 4th if you resolve.
Okay.
So that's possible.
All right.
Okay. All right, Mr. Butler, you're all set.
Okay. So I'll reach out. Right. I'll call Monroe. And who's his agent? Miller?
Number 32, People versus Leon Odom, 23832 FH.
Yes. We'll move it up if we can.
We waited that whole time and didn't hear what he did. That entire time.
Yeah, Jonathan Evans on behalf of People.
Torshio Feaster, Assistant Public Defender, on behalf of Mr. Odom, stand to my left at the podium. Please state your name for the record, sir.
Leon Odom.
Okay, so Mr. Feaster, have you had a chance to go over the case report on this from yesterday?
Yes, no. Yesterday?
No, it's working. Remember, I was in jail. I lost my home, everything. I just got a job, and I'm back working on my home. So you had told me to be here. I was here at 9 o'clock this morning. They told me you canceled me till 1:30. And I've been here.
That's not, I don't think that's the question. I think there's a new report.
Oh, I don't know, no.
That I don't have yet. It seems.
So I think so I did order you released on the 14th.
Yes, sir.
There's a case report from the 20th that details some issues from back in June.
Okay.
So I guess though, when I let you out last week, did you report to probation?
Yes, I did. I went down there that Friday. You let me go on a Wednesday.
Yeah.
Got down there that Friday.
Okay.
I guess I missed her time. I tried to call Miscellaneous.
So hold that thought for a second. Let's just cut to the chase of what we're doing today. It doesn't sound like are we likely to resolve this today? Are we going to be coming back? Like, before we get into
No, I tried to resolve it.
So the recommendation was previously for him to do 1 year in the county jail with credit for time served. The bulk of this violation was based on a new offense or new allegations. That case has been dismissed not once but twice at district court, and so that part I think is resolved. The additional part that he is facing is not completing some programming, the ADA program, not completing substance abuse assessment, and those are the things that he's primarily being accused of at this time, I believe. So I believe the recommendation prior to the new case being dismissed with 1 year, recommendation has not changed since that new case was dismissed. So I was going to ask Your Honor to sentence him to something to complete that programming. I think he has about 4 months left on probationary term right now.
So I just want to make sure we're all clear before Agent Seibert leaps the moment. But you just placed on the record that you thought the recommendation was 1 year in the county jail with credit for time served. My note.
I'm sorry.
So 168 when he was here before, credit and no early release. So he'd be going back to jail.
Right. I'm aware of that recommendation.
Okay.
He's asking you not to follow that recommendation.
I appreciate that. So
that was the recommendation. Like I said, when those new charges arose, they've since been dismissed. The recommendation has not changed.
I mean, I guess the question is it likely to change, Agent Seibert? Is there more information waiting for? Like, I mean, I don't know if they're.
I don't think they're gonna change, but I'll let
This one has reported since he was 14, like you said, he did, but we don't know.
Yeah.
So I guess that's not change the recommendation.
So hypothetically speaking, misunderstanding. Let's say that if the case was dismissed for the second time and that takes away some of the violation, might that change probation's recommendation if he did report as he was supposed to?
I think so, Your Honor.
So how about we adjourn this a few weeks? Mr. Odom, I don't know how to put this more clearly to you, but you need to report to Agent Gist by noon tomorrow, hook or crook. You can go down there now. Don't know if she's still there, but if she is, you could satisfy that today. If not, if you come in 4 o'clock tomorrow, 3 o'clock on Friday, I don't care what the excuse is or what happened. I'm looking you in the eye, telling you by noon tomorrow, you report to Agent Gist. You report to her and she says, Mr. Odom, I don't have time to see you today. Come back on Monday. You're good to go. Come back for your appointment with her. You meet with her, go over this. I don't want you to plead guilty or responsible to this violation of probation for me to have to make the decision today. It's possible that she's not going to change that recommendation, and I'll make that decision. But they're asking me to send you back to jail for 6 months.
I know.
So I want you to have the chance to meet with her, talk that through, and if she, either on her own rotation or she comes back, through a note through the agent that's on duty that day with me, We'll come back on September 11th and we'll deal with this, okay?
Yes, sir.
Does that make sense?
Yes, sir.
All right, so I'm gonna adjourn the VOP to September 11th,
Go down to the
just to
basement.
see what's going on.
Yeah, I'm
Okay.
finna down there. Lily, guess.
Yep, she was down there early.
Yeah, I know.
Okay.
Go down to the basement on the elevator today.
Yes, sir.
Ask for Agent Gist. If she can't see you, leave your information. Do whatever you need to make sure you see her or talk to her before noon tomorrow.
Yes, sir.
Okay?
Thank you very much.
Okay.
Nice.
Don't let me know, all right?
Yeah.
Thank you for the hypothetical, Agent Seibert. Appreciate that. We had every probation officer in the building up here. They were suckers. All fled. The heck?
Number 19, People versus Emmanuel Henry.
Quick note, Steve looked for Sullivan's arrest records, etc., and he wasn't in front of Judge Simpson. So now I'm pretty confused because I've never managed to watch Judge Slay, and I've only watched this judge once or twice, and he's so familiar.
Henry 2449 SH.
You're under, oh, sorry.
Poor Wilbur to the people. This is A. Paper, since I just messaged her. She stepped out briefly.
Ready again, Judge. Portia Feaster, Assistant Defender, appearing on behalf of Mr. Henry. Mr. Henry, please state your name for the record.
Emmanuel Henry.
Henry, can you hear us?
Yes, sir.
Okay, today's the date and time set for pretrial. There are some notes that might be a plea. What are we doing today?
Yes, Judge. I do have an email from Mr. Rosso. I've spoken to Mr. Henry on the phone a couple times. My understanding is that the offer is for him to plead guilty to count 1. Then count 2 would be dismissed at sentencing. There is no objection from the people for no upfront jail time. But this is not going to be a HIDA case.
Your Honor, thank you, Jonathan Emmons, on behalf of people. That seems to be correct. Oh, Morgan's here. Great.
Okay. I guess the only question I have, Ms. Barroso, is it true that there's a sentence agreement to no upfront jail?
That is.
Okay. All right. So, Mr. Henry, you understand what's on the table here is that you'd be probably pleading no contest, because that's why I have a police report that I looked at? Or?
That is correct, Your
So you plead no contest to count 1, count 2 would be dismissed at sentencing, and then there's a sentence agreement that you not be incarcerated up front for jail, be probation only. Is that your understanding?
Yes, sir. Yes, sir.
Proceed that way today?
Yes, sir. Yes, sir.
You understand that you have the unusual case where I think there's the Florida extradition that I'm not taking any position on. But if you can deal with this today and whatever I say to do, whether I release you or not, there is still that pending. You understand that?
Yes, sir. Yes, sir.
Okay. All right. I'm going to have you raise your right hand to be sworn in.
The testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Okay. So, sir, you understand what I just placed on the record and what Ms. Barroso, Mr. Emmons, Ms. Willenbring, and Mr. Feaster all kind of presented to me as far as what the agreement is, correct?
Yes, sir.
There is a sentence agreement that the prosecutor is not going to ask for upfront jail. And so that means that, you know, if everything goes well, that's what's going to happen. And it usually does go well. But you need to understand that if you get into any additional trouble or new trouble between now and the date of sentencing, I could ignore that and not agree to that. The other thing is, if I read your pre-sentence report, and it's so surprising to me, it's possible that I could not go along with that agreement as well, sentence you to custody, you know, some sort of incarceration, and then you've pled no contest to a crime, and maybe you won't be able to withdraw that. That doesn't happen very often, but under those two circumstances, you need to be notified that it's possible. Do you understand that?
Yes, sir.
Currently on probation or parole?
No, sir.
Okay, because this plea could affect those status, so I just wanted to know that. Other than what's been stated on the record, has anyone threatened you in any way to get you to plead no contest?
No, sir.
Has anyone promised you anything not on the record to get you to plead no contest?
No, sir.
Is the decision to plead today, no contest, yours to make, meaning you're not being coerced?
Yes, sir.
You understand that because you're doing this, you're telling me this today, you can't come back later and tell me your plea today was the result of any threats, promises, or coercion that you're not telling me about.
Yes, sir.
All right. You are pleading guilty to that count one. You're pleading no contest to that count one. That is a felony punishable by.
Sorry, I just want to interrupt so that there's enough time for people to answer. But you know, Judge King kicked that teenager out of court. Anyway, there's a press conference of the family. The family are going to sue. There's a cat in here somewhere doing something they're not supposed to. Do you guys want to watch that? Do you want to carry on here?
Up to 4 years incarceration or a $2,000 fine, and then DNA sample to be taken upon arrest. Consecutive sentence could be imposed if the assault was in a place of confinement. Those are the maximum penalties. I'm not saying that's what's going to happen, but you just need to, you get to be reminded of that. You understand that?
Yes, Your Honor.
Okay, I'm going to go over some rights that you're giving up because you're not going to have a trial in this matter. At a trial, you'd have the right to be tried by a jury, to be presumed innocent until proven guilty, and to require the prosecutor to prove beyond a reasonable doubt that you are guilty. At a trial, you'd have the right to have any witnesses against you come into court, and you would be able to question them when they testify. If you needed witnesses for your defense, I would order them to appear. At a trial, you would be able to choose to not testify or to remain silent, and that silence would not be used against you. Or, if you wanted to, you could testify at the trial. Do you understand each of those rights, and then by pleading today, you give them up?
Yes, Your Honor.
Okay, you understand that you're giving up certain appeals rights. One of them is that if you didn't like what happened at trial, you could automatically go to the Court of Appeals just by filing the paperwork. Because you're pleading today, you give up the automatic trip to the Court of Appeals, but you have to, it doesn't mean you can't appeal it. You have to ask the Court of Appeals for permission to take the case, and that court decides whether it's going to. It's not my decision. So you understand you're giving up the automatic appeal, and if things happen during trial or after, sometimes that gives you new reasons to appeal. So you give up those potential claims. Do you understand those appeal rights and that you're giving them up?
Yes, Your Honor.
It's getting late in the day. I'm just going to cut to the chase. Are you a U.S. citizen?
Yes, sir.
If you weren't, there would be immigration consequences, and I would have to advise you of them. But since you're telling me under oath that you are a U.S. citizen, then we'll go from there. Okay, having a senior moment here. I'm okay. All right, and lastly, certain crimes have reporting requirements on the offender registry. That may or may not impact you at all, but you just have the right to know that. You understand that?
Yes, sir.
All right. As it relates to count one, assault with a dangerous weapon, and let me remind you, I believe you are pleading no contest, Mr. Feaster. Is that because of civil liability potential?
Yes, sir.
All right. So how do you plead to that count one, assault with a dangerous weapon?
No contest, Your Honor.
All right. I've had a chance to review Ann Arbor Police Department Report 240014600 dated April 3rd, 2024. Counsel, do you believe that there's adequate information in the police report to support the elements of the offense found in count one of the information?
Yes, Your Honor.
Let's do, Your Honor.
All right. Either are you aware of any information, any promises, threats, or inducements other than those disclosed on the record?
Just what's on the record, Your Honor.
All right. Have I complied with MCR 6.302?
People are satisfied.
All right. I find the defendant's plea of no contest knowingly, understandingly, voluntarily, and accurately made. I am also satisfied that there's factual basis in the police report to support the finding that you are responsible for the offense of assault with a dangerous weapon as contained in the information in the court's file, and I will accept your plea of no contest. Prior to sentencing, you do need to do an interview with probation. Mr. Feaster, do you want to be present during that?
Okay.
All right. And are you arguing for bond modification today?
I believe he's held on that situation.
That is correct.
So I don't know. I guess my worry, so we're all good, Mr. Henry. What I don't want to happen is Florida to not extradite you to be released in like 6 days and then forget that you have to do the interview with probation. So what's a little unusual, Mr. Henry, is that if you were going to stay in custody through October, probation would come to you, do the interview, the pre-sentence report would be completed. If I was going to let you out today, I would order that you report to probation tomorrow morning to make the appointment for that interview. Because of the Florida extradition question, you may be released at some point in the next, 10 days, something like that. And I don't want you to leave the Washtenaw County Jail and think, sweet, I'm good to go. I don't need to do anything. Because if you don't make the appointment with probation, I'm going to issue a bench warrant and you're going to be arrested again. So are you following what I'm saying here?
Yes, Your Honor.
If they take you to Florida, all bets are off. Like, you got to deal with what's in Florida. And then when you're done with that, you come back up here for your sentencing. But if you don't go to Florida, ultimately you're going to be released from the jail. So what I'm going to order is that upon your release from the Washtenaw County Jail, you have to contact probation within 24 hours and set up the appointment for your pre-sentence interview. I'm going to schedule your sentencing as if you were released. So that's going to be October 16th.
Yes, Your Honor.
October 16th at 1:30 p.m. So that's the next court date. So whatever happens, you got to get in touch with probation if you get out. If you end up going to Florida, I don't know how we'll find that out. Mr. Feaster can make a call and figure that out. And if you end up, I don't know. I mean, I guess here's the deal. If you don't show up here in person on the 16th, I'm going to issue a bench warrant too. So I don't want you to get arrested mistakenly. I want to just take care of this. But you got to remember that if you get released, your obligation is to get into probation and get back here on the 16th. And I won't arrest you or remand you if things were delayed outside of your control, but there's just not a good way for me to get that information. Okay?
Yes, sir, Your Honor. And I got a question. I
Okay.
will also know myself, but when is my initial release date?
I don't know. You mean related to the extradition?
Yes.
I actually need that. I'm sorry, I need this spell back. I would release you on personal recognizance today. And so that would mean that you would be getting out tonight and you'd have to report to probation tomorrow morning. But because of the extradition hold, I'm not sure if that's going to happen. So I just wanted you to know that if they don't come pick you up from Florida, at some point they're going to release you. And once you do that, you're going to need to get to the probation office.
So I'm saying, like, I'm getting released tonight, or
I don't know, and I don't think so.
What Judge is saying is this case is no longer what's holding you. Now we're waiting to see what happens with Florida. But on this case, it is not holding you any longer.
Okay, so I'm asking, like, how many days do I have to wait for Florida to get me?
That's beyond my pay grade. I don't know. I mean, I'm kidding, but I don't know, because I would have you released today. But if there's something going on with Florida extraditing you, that's outside of mine or Mr. Feaster's control. And so that's going to be them notifying the Washtenaw County Jail that they're not coming to get you and that you can be released. So I just don't know the answer to that.
Okay. So I'll have to find out from here.
So you just need, all I can tell you is that when if they let you walk out the door of the jail anytime today, 2 weeks from now, you get a hold of probation right away so that you don't get violated and then get back in jail. Okay?
Yes, sir.
All right. So I'll see you back here unless there's been some delay that we can't do it, but come back here on October 16th and we'll figure it out. Okay?
Okay, I got you.
All right.
Any questions? You know how to get public results. You get called.
Come again, Mr. Feaster?
If you have any questions, give me a call at the public defender's office.
I got you.
Right. Thank you, Judge.
Out of state questions. How do we know?
Number 11, People versus Mitchell Cook, 19828 FH.
Okay. So majority voted to hop over to the press conference about Judge King. So in case you don't know about it, Judge King, he live streams. We've watched his live stream a few times. He had a visiting / job shadowing teenager arrested, handcuffed and put into juvie for sleeping in court. The mum came out and said that they are actually between homes, so the child is tired because she's not like getting enough sleep, and they've got a difficult living situation. Judge King is not going to be on the bench until he completes a class, and I don't want to say exactly what the class is, but it's got to do with like understanding and sensitivity or something like that. So here is the press conference. Her family is going to be suing him.
Good afternoon, everyone. Nice to see you. My name is James Harrington. I'm managing partner here at Feiger Law.
Before we go on, I just want to say it's their side that is only coming through one ear, not me.
To my right is Latoria Till. She's the mother of Eva Goodman, the reason that we're here. To my left is one of our senior trial lawyers, Gary Felty. He's worked with us for a very long time, and he'll be helping me out with the case. Eva is not here. This has been very hard for her. She was put on camera. She was live streamed. She was potentially put on a Facebook group with this. So we felt that it would be best that she not be here today. But we did feel that it was important to have everybody here today to discuss the lawsuit that we have filed today. The lawsuit that we have filed today is a 54-page lawsuit. We have named Judge Kenneth King as a defendant. We have named the security guard company as a defendant, and the two security officers who we currently do not know their name, but I believe we'll get the names in relatively short order, and they will be added into the lawsuit. The counts that have been filed against Judge Kenneth King are for malicious prosecution, unlawful arrest and incarceration, intentional infliction of emotional distress, invasion of privacy, false arrest, and false imprisonment. And the claims against the security company are for unlawful seizure and detention of Fourth Amendment violations, false arrest and imprisonment, and that the company is responsible under a theory of what's called vicarious liability. This is a very troubling case, and we had a member of our bench berate, humiliate, intimidate, and essentially incarcerate a 15-year-old kid. And this 15-year-old kid was doing work for the Greening of Detroit, planting trees, and there was a scheduled field trip that was had in Judge Kenneth King's courtroom. And she was tired, she fell asleep, and the judge didn't like that. So he yelled at her, and she fell asleep again. And then he humiliated her and had a plan that he was going to have her ordered to be placed in handcuffs, have her put on the Wayne County prisoner outfit that I believe it's green. I've seen it before, and on the video that I've seen, it's difficult to see, but had her placed in that. This is in front of all of her peers. This is being streamed. This is online. And then she was detained, and this took several hours. The whole ordeal was several hours in time. He accused her of being disrespectful. He says, "I don't like your attitude." Says, "What's your problem?" And Eva, she apologizes. She says, "I'm sorry." He then threatens her about the juvenile justice system and asks, "Is this where you want to go?" We can hear this on the video. I believe that the video has since been taken down. I have seen some clips. I know all of you have seen clips. And certainly through the discovery process that we will be engaged in as the case goes on, we will be gathering additional evidence, hopefully more video footage to fill in some of the gaps that we have at this point. But when Eva's asked, "Is this where you want to go?" after being threatened and scared about the juvenile justice system, she says no. She was taken against her will. This wasn't some planned event that Eva was a willing participant in. This wasn't some type of event where her mother signed off on a parental consent and said, "Hey, today we're doing this type of an exercise and the judge is going to be holding some type of a mock trial." None of that happened. And as far as Eva knows, that this was very, very real to her, very, very scary to her. And somebody in a position of trust, somebody that was in a position of authority and power is threatening her about jail time, is threatening her by literally placing her in handcuffs. And so that is why we're here, and that is why we have filed this case. I know some of you may have questions about judicial immunity, and potentially you may interview other experts in the field. I can tell you with 100% certainty that there is zero immunity for what happened in the courtroom on this day. The immunity applies only when the judge is acting as a judge in a court proceeding. This was extracurricular. This was outside of being a judge. There was no hearing that was going on. Eva wasn't a litigant. She wasn't a party. She wasn't a witness. She wasn't a lawyer. She wasn't a court officer. She was there on a field trip. This occurred outside of the scope of a regular court proceeding. In fact, the judge had a proceeding, had finished that proceeding, and then asked if anybody wanted to be a judge or be a lawyer, and only one person raised her hand. Eva has no interest in this. She wants to go into medicine. And her mother's in medicine. Her mother is a CNA with an urgent care over in Warren. And Eva's been exposed to medicine, has no interest in the law. I told my children, don't go into law. It's a lot of work, but she has no interest in law. And only one person raised the hand, and one of the participants, one of the kids, went and sat into the judge's chair. The problem with what this judge did was this was completely outside of the scope of what a judge should be allowed to do within any realm of decency, but outside of any type of proceeding. So I bring this up because the first thing that people will say, the first thing that his lawyers will say, the first thing that anybody interviewed would say is, "What about judicial immunity?" And I'll say it again, 100% does not apply. Under the facts that we know right now as we sit here today, judicial immunity does not apply. Judge Kenneth King is not immune for what he did. So we are asking that eventually we're going to be asking that he be held accountable. We have no role in any type of investigative process that may take place. We know that his docket has been temporarily removed. We know that he was teaching classes at Wayne State University, that he is no longer teaching. That is something outside of what we're doing, and our sole focus and purpose is to represent Eva and hold those responsible accountable. So the next steps that we have in this is we need to look into the extent of the live streaming. I don't have a lot of answers for questions as to what extent and to how much he was doing through a Facebook group that he has called, I believe it's King's Corner, if I'm not mistaken. And I'm not very techy, but I have heard that you can live stream things off of Facebook accounts. And I don't know how much he was playing to a public opinion on this, but.
Stop the lorry. I just said I don't know where I stand because it doesn't sound like the child is in a great home environment. That is what concerns me the most. She should be getting enough sleep because she has somewhere to sleep at night. That's my concern, right? Him saying that the judge was potentially streaming to a like playing to the audience. I just want to find, give me 1 minute. Okay, so they say this without checking. This is 1 hour, 7 hours ago. The judge isn't even there.
I'm here.
Yes, why are you on Zoom?
Thought I had court today.
Yes, in person at 11 a.m.
Oh, I didn't know.
Okay, it's in person, so, and it's at 11 a.m. We need you here
At 36.
at 36th District, yes.
All right, thank you.
All right.
Okay, so for him to make it sound like the judge was streaming this like for whatever, for like personal gain, I don't like that at all. Don't go in like that. Oh my gosh. Hold on. I'll be back.
That's something that we will be looking into very, very closely. We will likely be hiring expert witnesses in the field of computer forensics that can look into this to the extent some of those have been removed or no longer exist. We will find that out. And once we do, we'll certainly notify all of you of that. We would also, after today, because the lawsuit was just filed today, we'll be working to serve the defendants in this case unless one of their lawyers reaches out and tells me that they'll be accepting service. So we will be putting our resources into this. This is a very important case. As a member of the bar, I do believe that when things like this happen, we have to hold people accountable. We can't just say, well, because this is a judge, I'm not going to take this case. I mean, Eva, and her mother came to us and they asked us for help. And this is what we do. We help people, we help those in need. We take the tough cases, we take some of the unpopular cases, and we work very, very hard for our clients. So our focus is going to be on.
And I don't want to like fall on. I hope that the family can get a stable environment for the child. The cats are being so crazy. I don't know what just happened, but I'm sure you heard the skid marks as they ran. But like her saying that they don't have enough money for housing, but then she comes to the press conference with her eyelashes done. Like, I just think that they're presenting themselves the wrong way. The lawyer saying like, is he streaming this because, you know, he's got a fan base, when the court has continued to stream without him? And then her saying like, the judge needs to be more aware of like privilege and people not being able to afford the bare minimum, and the child is like in this difficult environment because the mom is doing the best she can, but she can't afford more. Like there kind of needs to be some consistency, and I think it's sad because I don't know who was wrong or right here. I don't think he was in the right, but if you think of it, like if you look at it from the perspective of like the two sides, you've always got to make sure if you're going to bring up things about other people, you've got to make sure you're clean, right? Like, I just think that the lawyer and her should have had a conversation about this and just like, yeah. Chini, I hear you. But the mom said in an interview that they are struggling with housing, and that's why. That they are couch surfing, that they're staying with friends, that they don't have proper housing right now. And that's my biggest concern. At the end of the day, I don't really care about the politics of it because I don't live there. I don't really need to worry about it that much. But like for me, I'm concerned about a child not having a proper place to sleep. Because if it wasn't in the courthouse that she was falling asleep, it might be at school. Like, yeah.
Eva, our focus is going to be helping to make sure that her well-being is okay, because this is extremely traumatic, especially what was done by somebody in a position of power like Judge King. So at this time, I would like to open this up for any questions. Please direct the questions to me once everybody's through. You can ask questions of Eva's mother. Yes, sir. Yes.
I saw you were pretty distraught. I can't imagine what your daughter's going through right now. Could you share with us how traumatic this has been for your daughter and your family?
I'm sorry? Yes. Go. Latoya, come on. And the question is how hard this has been for Eva.
It's been pretty devastating. Eva doesn't want to come outside. She doesn't want to be involved with no one else but family relatives. It's hard for her to sleep at night. She's asking me, why did the judge do me like this out of all the kids? Like, she's really not understanding the whole thing of the system or what happened or what's going on. So I wish I could have brought my daughter here for today, but she doesn't want to be in front of the camera. She doesn't want to talk. She's embarrassed, humiliated, and I can't blame her.
And what message do you want to send with this lawsuit?
Basically, I just want Judge King to take accountability for the way that he humiliated my daughter. It could have been anybody's daughter. It could have been your daughter or anybody else's your daughter. So that's how I feel. I feel like he owed her a public apology. Not only that, he owes her more than just a public apology.
Mr. Harrington?
Yes, sir.
I noticed that the agreement of control is not listed as defendant here. Did they have any duty to protect Ms. Till's daughter that day, and were there any steps on that organization?
No, that's a great question. And based on the evidence that I've seen, I don't know how they would have foresaw the judge taking these steps outside of being a judge. I don't know how they would have. So that wasn't something that we felt would be included in this case.
Hearing the facts early on, with reports that it was a field trip, I'm assuming there may have been some type of chaperones, questions about whether or not they could have stepped in when they saw this getting too long, too aggressive. Said that she was going through this for hours.
Yes. Yeah. And so it's important to understand that when we're contacted by a client and we're looking at the possible cases, because anytime something happens, there could be multiple individuals responsible, and it's not uncommon for, as a case develops, that amendments to pleadings be filed. And we will be looking into every aspect. It's just what we know at this time, didn't point to anything that would suggest that the Greening of Detroit should be a defendant. If there was evidence that was presented to me tomorrow, later today, over the weekend, that would support that, I would be compelled on behalf of my client to represent her and to bring that. But at this point, the evidence that we've uncovered wouldn't have supported that.
Mr. Harrington?
Yes.
Is there a specific dollar figure or financial figure you guys are looking for in this lawsuit? Additionally, any specific kind of discipline for Judge King, maybe from the Judicial Commission or anything like that?
Sure. Well, there is the Judicial Tenure Commission, which I'm not a part of. I don't have a seat on, and I'm not involved with in any way, shape, or form, and that's not my focus. My focus is on EVA. And ultimately, as the evidence begins to unravel, I did not want to put something into this lawsuit, and then all of a sudden, let's say I find more evidence through certain means, I didn't want to have a number that was too low. So I just wanted to just have the jurisdictional amount and move forward. And certainly when Mr. Felty and I are able to present the case in front of a jury trial, we will certainly be asking them for what we believe to be a large sum of compensation, because that's the only justice through this avenue that we can get, is compensation for EVA. But right now, what's really important is understanding the facts, understanding what happened, how we got here, and working towards that accountability and answers.
Do you believe the judge should be removed from the bench? We know that he is going through some training before his docket is returned to him, but do you think he should be removed permanently?
I believe that the judge should be afforded his due process rights and his ability to, just as I represent EVA and Gary represents EVA, I believe that whoever is going to represent the judge in this should be afforded their due process rights. And I think me making a statement about whether or not he should be removed because of this and this alone without having those due process rights probably wouldn't be very responsible on my part. I can't hear you. Can you speak up, please?
Judge King has been criticized in the past for his interactions with commenters on the YouTube stream, and I would guess on that Facebook post as well. Is that something you've looked at as part of this lawsuit, or is that completely separate?
It's developing, and I'm aware.
Question from Mom. When your daughter told you about this and you saw the video, what was going through your mind as a mother?
I was shocked because I couldn't believe what I was hearing. It was unexpected of what the behavior from a grown man in a courtroom was in my child. So I was speechless. I can't lie, I was speechless. I didn't know how to handle it. I felt enraged. I felt sad. I wanted to cry for my own child, and at the same time, I wanted something to be done.
So Judge King has said that Ava was disrespectful both through body language, but also through saying something. I know that you said that she apologized to the judge for sleeping. Can you elaborate on whether or not she said anything else to kind of precipitate the interaction that happened?
I'm going to ask you the question. You tell me what she could have possibly said that would make it okay to put this 15-year-old kid in cuffs, make her go in back, put on a jail jumpsuit, come out in handcuffs, and be put through the disrespect to her, the harassment, the humiliation, and threatened to be thrown into a juvenile facility. So come up with something that would make that okay. So there isn't anything that she could have said that would have justified what Judge King did to Eva in that moment.
I'm certainly not trying to defend the judge. I'm just trying to understand this is what he said, and
Right.
I'm trying to understand if she said anything else.
Right, and there are some portions that
The journalist is doing a good job there. He's trying to ask an objective question. again, I think the lawyer should have kept it kind of calm. He could have posed the hypothetical, but you need to, in a press conference, allow those objective questions to be asked so that it doesn't come across one-sided. And that's kind of what I've been feeling about the way this has been reported. Like, I would like both sides to be presented. I would like to know. I feel like it's been quite skewed. I mean, even if you look at this headline, family sues Detroit judge who ordered teen handcuffed on field trip, a big bully. I think, like, the question was a good question, so answer it calmly, and let's talk about it. She could have been ill or something, but that's for the lawyer to explain. Yes, like, she might have been ill. Just answer the question. Let's just be calm. Let's not be in a press conference talking about somebody getting too animated or angry too quickly, and then you get animated and angry quickly when someone asks a objective question. And I know it sounds like I'm being tough on him, but he is at a press conference and there's a certain standard for press conferences.
Are inaudible and they're difficult to hear, and I need to have the whole video, but I don't care what she said. I don't care what the fact that she was tired and fell asleep. I don't care about that. We have there's this document called Michigan Code of Judicial Conduct. These are canons that judges are required to follow. And I was going through these. Here's one. It says, a judge should treat every person fairly with courtesy and respect. He didn't do that. The judge must maintain public confidence in the judiciary, and it is eroded by irresponsible or improper conduct. A judge must expect to be the subject of constant public scrutiny. Okay, there's a lot of things in here. And here's one, Canon 3. A judge should be patient, dignified, and courteous when dealing with others with whom the judge deals. We could go on and on. So again, I ask you, tell me one thing that she could have said that would have made it okay while acting within the bounds of what's required under Michigan law and the judicial canons. He overstepped.
It sounds like, just to clarify too, you're not filing or haven't filed a complaint with the Judicial Finger Commission. That's not.
We filed a 54-page federal civil rights case. I have not filed anything with the JTC. I've not filed anything with the Attorney Grievance Commission. In fact, I've never grieved one lawyer in my entire practice. I try to fight my battles in the courtroom and try cases for my clients in front of juries.
And this is a long way down the road. You're suing Judge King in his individual capacity. I guess for monetary purposes, this, again, long way down the road, would this be tax dollars that he'd be using to pay out any possible settlement, or this is his individual?
That's going to be a question between him and the bargaining agreement that applies. I'm just pleading the facts as the facts stand, and whether or not he gets insurance for this, because there is insurance that every entity in the United States has. So this is a case, there could be insurance. Frankly, I don't care. I plead the facts as they are, and if an insurance company decides not to indemnify him and pay for the conduct that he did, that's not my concern. My concern is this little kid and what she went through.
Ms. Ciele, you obviously have been there with your daughter since this happened, and you've been able to see how it's impacted her. What would justice look like for you?
I just want to see my baby smile again. Just want to be her. I just want her to be herself, be happy. That's my justice. I just want my baby to be happy. I want her to come back out and be with her friends and be the normal.
Wait, when he was talking about not filing with the judicial board, they haven't filed a complaint against Judge King? So they're only doing a civil suit? Or they haven't filed before this?
15-year-old girl that we all was once upon a time. That's all.
And Ms. Ciele, if you could recap just the life circumstances that led her to fall asleep in that courtroom that
As far as me and my children, I have 2 kids, 2 girls. We do not have a permanent residence right now. We do go back and forth between my mom's house and my aunt's house. And so that's our current situation. When I go to work, as any other normal day, I take her to school or work. My other child continue on to her education and extracurricular activities. I don't stop for nothing. This was just happened to be something that unexpected, deadbolt. It stopped in my tracks. It's actually a hindrance right now on my life, to be honest.
What was your understanding of the field trip that day? Was your daughter employee of the Ringling Choice, or was she part of a summer program? Can you give me some context there, or what your understanding was why they took the students there?
I cannot tell you why the children went to 36th District Court that day because I had no idea. I dropped my daughter off again as 8 o'clock in the morning to go to work. The transportation vans take them to their work zone. They're supposed to be planting trees or learning how to become productive, successful grown-ups in the world. They're young teens. They don't have any legal troubles or mental problems. They're good kids. And so from my understanding, it was supposed to have been a learning environment situation, maybe. That's what I know about it.
I'll take one more question, and also on your way out is a copy of the complaint if you don't have it. I believe it's been circulated to everybody, but there is a copy there for anybody to take.
Can you sum up Judge King's actions in those 2 or 3 minutes that he made these decisions?
Sum up his actions?
His actions and his reactions in those 2 minutes that he made that decision to put him in custody.
He crossed the line. Period. He crossed the line.
Big bully.
Okay. Yeah, I don't know. I don't know where I stand. It is weird to me that they haven't filed with the ethics board. I think that's a bit weird. I don't like how he handled it, but I am very concerned that she did not have an adequate place to sleep to the point where she was so tired the next day. That's not really conducive to, you got to go like Maslow's hierarchy, like that brings me concern. If she wasn't in court, she'd probably be in school, right? Like she'd be tired at school. Yeah, I think it's a tricky one. I think it should play out in the judicial system. I think that I'm not going to have any like definitive comments. I just did want to point out some of my frustrations in the press conference, because I often get frustrated. So like if you're new here, I'm a journalist in South Africa. We have very different press standards. I often get frustrated with US media, like as a whole, and I wanted to point out like how skewed things have been shown, and also like what I would expect from a press conference. Like, for example, not getting angry with the journalist asking a question that was an objective question. Like that kind of thing to me is just the lawyer being ready to do the press conference and having the answers straight, etc. Anyway, I've got a premiere starting very soon, and it is an old Judge Simpson one that I actually edited by accident 3 times. So I'm going to send us there when I'm done. Yeah, same, Steve. And it's so chopped up. I want to see the full thing. I want to see the entire interaction. I'm happy to redact it. If you find it without anything cut out, please feel free to send it to me. And I am happy to redact. I'm happy to blur. I will cut her name, even though what's also confusing for me is that the family is saying, like, she just wants to leave it behind her. She doesn't want everyone knowing her name. But then in the press statement that was given to the media outlets, they specifically name her name and surname. Like, that kind of thing is just weird to me. I don't think that should be the norm. They should have redacted the name and just said the 15-year-old. That's totally fine. Anyway, I would like to cut it myself. So if you do find it, I can redact it like I did Judge DeSanto. All right. Anyway, tomorrow between 1 and 2 my time, which is my normal stream time, I am going for my tooth consultation. Finally, I should be back around 3, but obviously I'm going to have to jump into work. However, tomorrow, Judge Simpson, we have Eric Vermeulen, if he is going to be there, because they said he was ill today. We've got someone called Atkins. Don't remember who that is. We've got Jones. We've also got Christine Ricci's sentencing. And then I was hoping to find the 18th District Wetland Court. There's cousins having a self-defense pre-trial of sorts. That actually was one we watched in Judge King. I haven't found the 18th District Court yet. I hear you, Chini, but I just need to see the whole thing myself, because all I've seen is cut clips and I need to know the full thing. Like, I need to watch it myself without the spin that the media's put on one part or on the other part, or like going and finding snippets of old things, or like bringing like random stuff into it. I just want to watch it objectively. Follow judicial misconduct and move on. If they'd filed the judicial misconduct and then like a civil suit, the civil suit is $75,000 and majority of it is for past, present, and future pain and suffering, medical expenses, psychological and psychiatric treatment, exemplary damages, and attorney and expert witness fees. So cool. No problem with that. I seriously don't like that medical costs could come to that much, but that's a whole different conversation. Anyway, let's head over to the premiere. I will see you guys hopefully tomorrow, but I'll be in the chat with the premiere now. Bye.